My lord,
Give notice to your other side.
Notice, I'll give you. With notice.
my lord, may I permitted to mention one group 9 hearing matter, my lord.
Of
Two-
which year?
2003. 2003, my lord.
2000?
3, my lord.
Assigned matter item number 1.
Time for the response, Madam, for the petitioner. Lord. Almost the hearing has been concluded. But my friend, learned friend, has not yet submitted the written notes of arguments.
That
And but I wish to submit for a few minutes regarding the new points taken in reply regarding the constitutional provision and certain other things. My lord. I'll be taking 5-10 minutes.
My lord, I have a preliminary objection. Once the reply is given, there cannot be reply to reply. My learned friend had
So that's
submitted.
correct. That's
My
correct.
friend had
My lord.
submitted. Oh, just a minute. My friend had submitted only the judgments I had submitted before your lordship. That would be countered, and one judgment he wants to rely upon.
Yes,
So
that is what.
that much only. The new points I have not
That is
taken
what.
any new
That
point.
is what I'm not going.
I have
to
not taken
raise
any new point
I'll
on
be
this.
Okay,
distinguishing.
if
Yes.
yes, new point, you will raise objection. Okay. Allow him to proceed.
My lord,
Yes.
my lord, in reply, my learned friend has raised a question with regard to Article 166 of the Constitution of India, that if something is done by the government in the name of the governor, that cannot be questioned. Now, my lord, in my humble submission to this, my lord, this is not applicable at all, because the question arose whether the circular or the purported order is notified or not. It is not the question whether it has been issued in the name of the governor or not. If your lordship kindly sees Article 166 of the Constitution once. May I read it for your lordship?
Yes.
166. Conduct of business of government of a state. 1. All executive action of the government of a state shall be expressed to be taken in the name of the governor. There is no dispute with regard to that. Sub-article 2. Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the governor. So, if the governor has specified something to be done in a specified manner, that has to be followed, and it cannot be questioned that it has not been named in the name of the governor. This is sub-article 2. Then 3, the governor shall make rules for the more convenient transaction of the business of the government or state and for allocation of among ministers. This is not required. So, my lord, the question raised by my learned friend is that it is not an order or instrument made or executed by the governor. This is the question. My humble submission to that effect is that, my lord, I have specifically raised in my written notes also that the second there are 3 notifications. First notification is the rule, second notification is the rescindment, third notification is the amendment. The first and third one are notified. The second one is not notified. At least till date, it has not come before your lordship, the gazette notification. I have raised the question that this particular notification had to be gazetted. Otherwise, this could not have been taken into consideration. I have not raised the question that it is not raised in the name, not issued in the name of the governor. So, my lord, Article 166 has no role to play so far this case is concerned. This is number one. Secondly, my lord, my learned friend has placed a judgment of 1987 Volume 2 Supreme Court Cases 516.
নামটা একটু বলুন।
এখানে 87 এর কেসটা judgment দিয়েছে, আমি তো
নামটা
citation-টা লিখে দিচ্ছি। But here, this case is absolutely factually different. Here, the control of the government has been emphasized by the Honorable Supreme Court in a case where the provision for prior permission is there. For doing recruitment or anything, prior permission from the government was necessary in that particular cited case. In this case, my lord, this 1973 rule is a completely self-contained rule where no prior permission is required for the purpose of recruitment. So this case is factually distinguishable. Now the second case is 2013 Volume 10 Supreme Court Cases 324. Here also, my lord, the rules covered in the cited decision is completely different from that of the 1973 rules. That is also factually distinguishable. 2013 10 Supreme Court Cases 324. And the third one, my lord, is 2021 15 Supreme Court, page 600. There, my lord, my learned friend relied on this judgment that it is the policy of the government to rescind the rules. That was his submission. Here, the case is completely different. This case is with regard to abolishment of a particular class 4 staff in a rule. It is not a case of the 1973 rules, which is at hand before your lordship today. So these three cases are factually distinguishable. My learned friend has sought to distinguish my submission with regard to the notification. The judgments which have been cited, those of single bench and division bench, there, my lord, the rescission part, this notification and the rescission part has never been raised. And my lord, my learned friend has raised the question that it is barred by res judicata. I respectfully submit, my lord, when the question is raised that a particular order is notified or not, or the gazette is not there or not, this is a purely question of law. This is not based on facts. Whether a rule is notified or not, it is pure question of law. There cannot be any question of res judicata. If it is raised for the first time today before your lordship since 1973, your lordship can very well look into the matter. Notwithstanding the fact that the earlier division benches or the honorable courts, your lordship's coordinate benches, have not dealt with such issue. But same submission with regard to constructive res judicata also. Since it is a question of law, the concept of constructive res judicata, as enumerated in section 11, explanation 4 of the Civil Procedure Code, as your lordship knows, that will also not be applicable. Now, my learned friend has submitted that notification of a, gazette notification is a legal fiction. Here, my lord, I join issue by submitting only one decision of the Honorable Supreme Court. Gazette notification.
96.
Ah. Gazette notification, my lord, is a matter of rule. Lordship knows, my lord, any rule or bylaw or, my lord, subordinate legislation, these are called subsidiary legislations. Now, but according to the interpretation of statute, the subsidiary rules or the subsidiary legislations, those will be governed by the Parent Act. Now, if my lord sees the West Bengal Secondary Education Act 1963, Section 45 empowers, my lord, state government to make rules. Section 45(1), may I read it for your lordship,
Yes.
of the 1963 Act. Power of state government to make rules. 45, subsection 1. The state government may, after previous publication, make rules for carrying out the purposes of the Act. 2. In particular and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely, then the provisions are there.
Subject.
Yes. In clause D, the composition, powers, and functions of managing committees of institutions. Therefore, in terms of section 45 2D, 45(1) read with 2D. Lord, the government is empowered to make rules, and publication of rule is mandatory in terms of section 45 of the Act. So, my lord, if we go back to the principles of interpretation of statutes, my lord, this has to be published prior to promulgation. Now, my lord sees the management rules, how it was brought in force. My lord, I'm fortunate that I could find out the old book in my chamber. At one point of time, my father had used it. There, my lord, I find in exercise of powers conferred by subsection 1 and in particular by clause D of subsection 2 of section 45 of West Bengal Board of Secondary Education Act 1963 as amended by West Bengal so 69, the governor is pleased hereby to make rule after previous publication as required by subsection 1 of the said section, the rules for management so 1969. So this is the opening words of 1969 rules. This was made under the provisions of section 45, subsection 1 and 2 of the Act. So Parent Act was followed. Now, my lord, in 1973 rules, my lord has already considered, it is specifically written that in terms of management rules of 1969 under rule 33, this rule is being promulgated. So the power given by the 1969 rules under rule 33 has been exercised in bringing the 1973 rules. Now, if your lordship kindly sees the two subsequent notifications, the purported one and the gazetted one, the rescindment order, my lord, I raised a specific question in my notes that the language is doubtful. Here, lordship will kindly find at page 10 of my notes. May I read it for your lordship?
Yes.
In exercise of the power conferred by Articles 26 and 30 of the Constitution of India, read with Rules 33 of the Management and Recognized Non-Government Institutions, Rules 1969, the governor is pleased hereby. So, this particular expression in terms of section 45 of the Act, this is specifically, my lord, absent. Conspicuously absent. Now, if your lordship kindly sees the subsequent notification by which the government amends in 1983, the language. In exercise of powers conferred by subsection 1 and in particular by clause D of subsection 2 of section 45 of the West Bengal Board of Secondary Education Act 1963, read with Rule 33 of the Management Rules 1969. So the language is absolutely akin to what is there in 1969 Act, 1969 rules when it was brought in force. Milord, I don't say that 1976 rule, 1976 order was not there. It may be in the file of the government, but it was never brought into light. Lordship knows, Milord, a similar situation is there in our country with regard to Hire Purchase Act. The act was brought, but it was never gazetted. This is a similar situation. It may be in the file of the government, but it was never gazetted. That is why the gazette notification is not there. So, on my humble submission that this 1976 notification could not be relied upon, and that is absolutely non-existent for the purpose of considering the present case. But only one judgment I'll be citing. It is 1996, Volume 6, Supreme Court Cases, 634. Well, this is a parent judgment with regard to the law regarding the subsidiary rules. If my lord kindly sees paragraphs 14, 15, and 16 of the judgment. This judgment was delivered by Justice B.P. Jivan Reddy, where his lordship was pleased to quote another celebrated decision. Lordship kindly straightaway goes to page 647 at paragraph 14. To the same effect are the observations in B.K. Srinivasan versus State of Karnataka, while pointing out the importance of subordinate legislation in the affairs of the modern state. O. Chinnappa Reddy, judge, speaking for himself and Justice G.L. Oja, made the following observations. But these observations, may I submit, my lord, this is holding the field till date. May I read it for your lordship? But unlike parliamentary legislation, which is publicly made, delegated or subordinate legislation is often made unobtrusively in the chambers of ministers, a secretary, a government, or other official dignitary. It is therefore necessary that subordinate legislation, in order to take effect, must be published or promulgated in some suitable manner, whether such publication or promulgation is prescribed by the parent statute or not. It will then take effect from the date of such publication or promulgation. Where the parent statute prescribes the mode of publication or promulgation, that mode must be followed. Where the parent statute is silent, but the subordinate legislation itself prescribes the manner of publication, such mode of publication may be sufficient if reasonable. If subordinate legislation does not prescribe the mode of publication, or if the subordinate legislation prescribes a plainly unreasonable mode of publication, it will take effect only when it is published through the customarily recognized official channel, namely the official gazette or some other reasonable mode of publication. Therefore, my lord, three situations have been contemplated. Firstly, if the parent statute says something, that has to be followed. Exactly what is in our case. Parent statute says publication is must, so the publication is must. The other two situations are there. If the rule says something, that has to be followed. If everything is silent, even then the gazette notification is must. That is what the observation of the Honorable Supreme Court as recorded here. Then, paragraph 15. The above decisions of this court make it clear that where the parent statute prescribes the mode of publication or promulgation, that mode has to be followed, and that such a requirement is imperative and cannot be dispensed with. So I'm relying on paragraph 15. Then paragraph 16. Government memo number 201 purports to exempt a class of persons from levy created by a statute. A levy created by a statute can be lifted, suspended, or withdrawn only by a statute in the manner prescribed by the statute creating the levy. Dispensing with the levy or payment of tax is a serious matter. It is done only with a view to promote a countervailing public interest. Where such a power is conferred by legislature upon any another authority, the authority has to and can exercise that power only in strict compliance with the requirements of the provisions conferring that power. It is in the interest of the general public that such notifications are not only given wide publicity, but there should also be no dispute with respect to the date of their making or with respect to the language and contents thereof. We see no reason to hold that while the other requirements mentioned in section 11(1) are mandatory, only the requirement of publication in the Gazette is not. We see no reason to make such a distinction in the context of the said subsection. The power given by section 11 is of a substantive nature, besides being a nature of an exception. For this reason too, the provision conferring the power has to be complied with fully, that is in all respects. Therefore, here also the Honorable Supreme Court says that Gazette notification is mandatory. So, I am relying on only this decision with regard to the submissions made by my learned friend. That is a legal fiction. It is not. It is not a legal fiction. It is mandatory.
Yes.
And the last but not the least, so far the virus of the rule is concerned, the constitutionality part, that has not been raised by my learned friend in his submissions. My learned friend's submissions are completely restricted to the existence of the rule, whether rule is there or not. If the rule is there, then the rule is supposed to be valid. But these are my submissions. I'm grateful for patient hearing. I'm deeply only but I'll be submitting, if my learned friend is submitting the copy, but a copy may be served upon me.
No argument on that, right? No argument on my written note of part.
Oh, it didn't reach it.
I'm just court ke devo to. Submit it to. There is no argument on my written notes. It's okay. You take it. I'm giving you. Have it. My lord, before I initiate my submission, my lord, we have argued extensively before your lordship. My lord, I would just like to take a confirmation from my learned friend whether he will again start from my written notes of submission, because it is between the court and the litigant. So
written notes, my lord, he has already submitted. On that basis, he will submit simply.
So I want to get, because again there has to be a reply then. So I am.
No, if he is raising any new point, then I'll definitely
nothing. Whatever he has said. Now, not on my written notes of argument, because it's between the court and the litigant. I'm submitting before the court.
If something new comes in the written notes, I will.
Then, my lord, let him go through and make submission. Then I will make submission, because again,
on that date, we all decided that written notes of argument will be supplied prior to this date.
Well, my lord, this is
So that
I have submitted long back.
occasion to go through the same.
Because, my lord, my learned friend had added judgments in his written notes of arguments, which was not placed initially before the honorable court. So it had to come to me.
And it
That's
is
why it has been.
expected that what you have stated
But
orally,
nothing new, whatever
that
I have
has been
submitted,
recorded, that must be recorded in written statement.
it is already there, my lord. Nothing new I have
Time of
stated.
writing, nothing new would be.
Nothing new,
No.
nothing.
If it is not nothing,
Nothing
new,
new.
I'm not anything to say.
Kindly,
Okay, you proceed, you proceed.
kindly go through it. My lord, the first proposition, what my learned friend had argued, is that regarding Article 166,
Yes.
regarding the
Judgment.
the power of the governor
Hmm.
and the ministerial authorities to bring any law which cannot be challenged in question. So it is the general presumption that it cannot be challenged. And why I made this submission, why I showed that article, because my learned friend had raised question on the language of the order. He found some grammatical variations, and it was also part of his late submission that the languages are not matching. My first humble submission before your lordship, this notification has many times been considered from single bench, division bench up to Supreme Court. This notification has been considered. So it is obvious that the notification has passed through the judicial scrutiny. So had it not been proper or improper, whatever that the honorable courts had the occasion to consider, and now this point has been settled since that notification has been accepted and put a seal over it, that yes, due to existence of this notification, there cannot be any special rule. So, my lord, it has been tested. It is a litmus test, if I say humbly, my lord. This notification has stood the test of time. It has passed the litmus test of the judicial scrutiny, and it has been accepted. So it is a desperate attempt to somehow vitiate that notification in any manner possible, even going to challenge to the language of that notification. So it is a futile attempt, in my most humble submission, I say. And my lord, in that event, to be more sure regarding the veracity of the document, my client had made an RTA application seeking information from the government itself that kindly show what is the status of the special rule, what is the rescission, whether at all there is any rescission. Now, my lord, the authority has responded through, yes, I'm Dakachi. Yes, my lord, if your lordship kindly take the additional supplementary affidavit on behalf of the petitioner.
Yes.
Page 11. On 7th December 2022, my client had made an application, RTA application, and the Deputy Director of School Education writes back to my client regarding RTA application of Anand Kumar Singh dated 10th of September 2022, memo number such and such. With respect to the memos under reference, the undersigned has received photocopy of order number 1014 EDN S dated 10th of November 1976 of Education Department, Secondary Branch, which is hereby forwarded to him for his information. It is coming from the highest authority, Directorate of School Education. The same notification annexed on the next page without any variation. So the desperate attempt on the part of the school that this notification is incorrect, improper, the languages are not proper, is absolutely untenable, my lord, in my most humble submission, because the government itself is providing this notification and acknowledging and accepting the rescission notification. So, my lord, I try to hit both the points of the state as well as the school that the rescission of the notification is nullity in the eye of law. If I understand correctly, they had tried to make a point that state make a very interesting point that we are not aware of it. And the school said that it does not exist in the eye of law since it has not been.
State has said they have not issued it.
But the deputy director writes that it is existing. So it is their stand. This contradiction is there. Now it puts the final nail on the coffin of the submission that notification is not correct or not properly languaged. My lord, the deputy director itself under RTI Act provides this notification, page 11 and 12. So the submission possibly does not stand in my way. And my lord, why I showed Article 166? Because a question was raised on that. That is why. Now, my lord, the next submission, much emphasis has been put on no gazette notification. No gazette notification, nothing. I again, at the cost of repetition, I reiterate, this point has already been diluted, passed the litmus test, and merged with the decision of the Honorable Single Bench, Division Bench up to the Honorable Supreme Court, as well as the Deputy Director's letter that this rule is in vogue, it is existing today. If your Lordship kindly takes a look of that Deputy said, possibly Lordship has gone through already. The Deputy Director says that this decision is existing. So the question of no gazette notification does not arise at all. Now, why I submit further, most respectfully, that it is not required. Not all the notifications are required to be gazetted. Then, my lord, every day only gazette notifications will come in our way. Memorandums, orders, notifications keeps on coming. Now, my lord, not all the your lordship has gone through possibly thousands of notifications. I put this question to myself: are all these notifications gazetted? Without that gazette notification, nothing happens in this state or in this country. All notifications. We have seen OMs. In central government, we find OMs. Here we find GOs. Now notification, several notifications. Now, my lord, it is not proper to say just because it is not gazetted, it is not. It is not, my lord, acceptable. Now, my lord, as I already submitted, it has been considered by the single bench, division bench, and Honorable Supreme Court as well. So this point would have been decided by them that no, it has not been gazetted, it cannot be accepted. It has been accepted, it has been acted upon. Now, once it has been acted upon, now, my lord, it cannot be requestioned and reopened today. And my lord, this respondent school was party in most of the petitions. Their trust was party in most of the litigations. Now we cannot reopen it. Now, my lord, so for the point of res judicata, I joined this issue with res judicata. It was stated that pure question of law, it can be raised again and again. Doesn't matter whether litigation has put an end to it. Every time, whenever a litigation comes, we can come with pure point of law again and again and again, the same point of law. Both res judicata and constructive res judicata, which ought to have been taken. Now I put this question to myself: why you did not take this point before the single bench, division bench, up to the Honorable Supreme Court? Why? Why did not you hit the point that this notification has not been gazetted and it cannot be acted upon? Now, we have to give a go-by to Section 11 of the CPC. But I'm just putting for my satisfaction, res judicata. No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim litigating under the same title in a court competent to try such subsequent suit or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. My lord, I lay emphasis on no court shall try any suit or issue in which the matter directly and substantially in issue. And the last word, and finally decided by such court. Now, constructive res judicata. The point you ought to have taken, you have not taken. Today, you cannot raise it. So, both by res judicata and constructive res judicata, my lord, today it is not possible for the school authority to come with this. More so, even if I give a temporary go-by to this res judicata point, even if they had the point, they had accepted and they have acted upon. My lord knows it very well. When a proposition has been acted upon by a particular party, he cannot come back and challenge it again. It cannot. There cannot be reprobate and approbate every time he comes with a litigation. He had the occasion to challenge, never challenge, comes res judicata, constructive res judicata. Second point, you have acted upon, you have accepted the proposition of the Supreme Court. You could have gone for appeal, you could have gone for review, you could have gone for recalling of the order, saying that it is not a valid legislation. Could have. Nothing has been done. Today, for the first time, after everything has been settled, now this is coming before your lordship. Not permissible. Now we have to forget then, if we accept the submission of the school, we have to give a go-by to Section 11 of CPC and the very celebrated and established judicial principle that once a party to a litigation accepts the outcome of a litigation, he cannot come back and challenge. And that too, after decades, if I say, even though there is latches and limitations on that. This is my another submission. Now, my lord, possibly the judgments which I had cited, which was countered by my learned friend, had not been considered in its true sense. I do not know why this submission was made subject to correction regarding 1980.
But don't distinguish
No,
as he has distinguished.
my lord, he has distinguished my points. I have
Okay,
to. No,
okay.
I'm telling you, lordship.
He distinguished.
No, I'm telling you, lordship. It has been because your lordship had taken note of that distinction. I tell you, lordship, it has been absolutely wrong. Why I tell you, lordship?
Why shall I do? I am duty bound to address
Yes,
all of your
absolutely. I'm so grateful to your lordship.
Will you
My lord,
give me
only
relief
one
from
line.
that?
No, I only one line, my lord.
I have to say, Mr. Lahiri has submitted such and such.
Yes,
I am
yes.
duty bound to do.
Absolutely. No, I just to clear the mind of the court,
Yes.
my lord. Just it's my duty, my lord. 1980 regarding 91 line only. 1987 AIR, it has been stated prior permission not required. My lord, the judgment speaks otherwise, completely different. That if you are, whether you are minority or non-minority, when there has to be a state control in your regular affairs. That is the purport of the judgment. I do not know why this submission was made. Prior permission not required. My learned friend said that in this judgment, prior permission was required. But in our case also, prior permission is required. I showed to your lordship that board's notification 28. Lordship, kindly, I'm not troubling your lordship again to place those since we are at the verge of conclusion. My lord, lordship have already considered that notification which said that you have to take prior permission from the board. Your lordship recalls that. So, my lord, this distinction disperse into oblivion, nothing. Completely same. Their case, it was stated prior permission required in this case, my case not required. I already showed that it is required in my case. 28 read with the notifications and the page numbers I had already given. So this distinction is not correct. Secondly, my lord, 2013 10 SCC, my lord, I do not know. I expected something else. It has been stated rule 1973 has not been considered. My lord, did I place this judgment to establish rule 1973? I pose this question to myself. And the answer is in negative. I did not place this judgment to establish rule 1973. It is only, this is a celebrated judgment of Dipali Kundu Survasi. It is only on the point of the back wages. What would be the consequences? If today it is held that this disciplinary proceeding is bad in the law, so natural outcome is that I'll be taken back. Even if your lordship does not decide in this litigation, because Supreme Court has already, when it has remanded before your lordship, it's been limited, scope is very limited before lordship. Whether this rule or that rule, that much only. Now the natural consequences will follow. Now I place this judgment on the point, it is a celebrated judgment, Supreme Court has decided time and again based upon this judgment, it's a mother-parent judgment, that when an employee is taken back, when his discontinuation of service has been done wrongly, he is entitled to the back wages. I am on that point. I don't know why the rule 1973 has been brought into. There is no nexus with it. So this is my second consideration, my lord. Lastly, 2021 SCC online, which was again tried to distinguish with rule 1973. Again, I say, rule 1973 has not been considered. I have not placed it for that. Only for the legal proposition, which it says, be you a minority or non-minority institution, if you're receiving government grant, you cannot be left alone to do your things the way you want. There has to be government regulation. Just because you are a minority institution, that does not mean that you can do whatever you want. Administration does not mean maladministration. My lord knows the celebrated judgments, several judgments this has been stated. St. Thomas is there, Francis is there, everywhere it has been stated that admittedly Article 30 gives you the power, gives the minority institutions the power to administer, but it does not mean that you will do maladministration. So on that point only, there is no nexus. I'm on the point of law, the minority point. That 1973 rule is not the issue here. Merely you are a minority institution, that does not mean that you will be scot-free. There will be no regulation of the state. Because
I've got
yes,
next.
my lord. Because minority, non-minority, there has to be state regulation in cases of the disciplinary proceeding and other employee-related issues. Now, my lord, the next submission is that again, my learned friend had submitted the judgments I cited. I had not discussed the rescission point. I only tried to establish that rule is existing. My lord, I failed to understand for last 4 days what have I done before your lordship. That I had showed all the judgments on the rescission point. Justice Datta's judgment, my lord Justice Girish Chandra Gupta as his lordship then was his judgment. My lord Justice Chatterjee's judgment at her lordship then was the Supreme Court's judgment. Everywhere the rescission point has been taken into consideration and has been stated. I had twofold submission. Possibly I could not reach to the mind of the opposition that what my submission is today. I have two submissions. Firstly, that rule is not existing today, special rule, and the rescission was there, and rescission is valid. And all the judgments speak on that only. I don't know why this submission was made. Rescission point was not discussed. Throughout, I had discussed the rescission point only. Anyways, I consider it to be unnecessary. I do not go into that. Now, my lord, my learned friend had submitted this 1996 judgment of the Honorable Supreme Court.
Column 6, SCC, page 634.
Yes. Yes. তোমার জাজমেন্টের দাও না, বুঝতে পারছি না, দিয়েছিলাম আমাকে তো একটা কপি, না একটু দাও না। Well, kindly give me a moment. Thank you. I'm grateful to my learned friend. My lord, paragraph 14, 15, 16. My lord, kindly appreciate this judgment is of fiscal law again. It is ITC Bhadrachalam paper boards and others versus Mandal revenue officer AP and others. It is on income tax, including other laws. My lord, it is a judgment on fiscal statute. My lord knows it very well, the difference between a fiscal statute and other statutes. Application of a fiscal statute is absolutely different from a general statute, other statutes. Fiscal statutes have retrospective effect, which is usually not there in the general statutes. It is based on that, my lord, we have to be ready while distinguishing these judgments and reading this judgment that in which context this judgment was passed. It is on the fiscal issues. Fiscal statutes are different. They have retrospectivity, they have prospective effect differently.
And hence distinguishable.
And distinguishable. Now, my lord, very interestingly, paragraph 14, 15, 16 has been relied upon. My lord, 15 is the culmination of the previous paragraph. It says, the above decisions of this court make it clear that where the parent statute prescribes the mode of publication or promulgation, that mode has to be followed and that such a requirement is imperative and cannot be dispensed with. So, my lord, we understand that the parent statute must give a way out, must contain a provision which says a specific mode of publication or promulgation, that mode has to be followed. Now, my lord, if this is the sum and substance of the judgment which my learned friend relied upon at his cost and peril, now I take the rule. My lord, kindly take the trouble, kindly for once, for my satisfaction,
Yes,
kindly take the rule, which is attached with the compilation itself. My lord, my first submission is that the rule itself does not contain any provision. My learned friend has submitted, the judgment says, the above decision says, decisions of this court make it clear that where the parent statute prescribes the mode of publication. Now, is there any mode of publication prescribed in the parent rule, the special rule? I pose this question to myself. The answer is no. There is no
Only subordinate legislation.
I come to that.
It would remain in the parent legislation. Rule-making power shall remain in the parent legislation, not in subordinate.
Subordinate. Now, this is a subordinate legislation.
Legislation will come in exercise of the power of
absolutely
given in Parent Act under section such and such. I am making this rule.
Absolutely.
In this way,
absolutely, my lord. Now, my lord, kindly take clause 19 of the rule. I'm placing it before your lordship. General applications of the rules. That is the special rule. Clause 19. In matters not specified herein, the school committee shall exercise powers in conformity with the provisions of the rules or orders issued by the state government or any other authority competent to issue such orders or frame such rules under the provisions of any act of rules framed thereunder. In matters not specified herein, the school committee shall exercise powers in conformity with the provisions of the rules or orders issued by the state government or any other authority competent to issue such orders or frame such rules under the provisions of any act or of rules framed thereunder. So, my lord, it specifically says the school authority is bound to follow the orders issued by the state government. Orders, nowhere it says it has to be gazetted notification. The rule itself says the state government has to follow the school authority has to follow the orders of the government. It's orders. It does not specify that it has to come through gazette notification. The state has to make gazette publication. Otherwise, had it been the intention of the legislature, that would have been there in the rule itself. The court or we cannot go beyond the statute and read beyond the lines, which is not there in the rule. Now, the clause 20, amendment of these rules. These rules may be altered, revised, or amended according to the exigencies of the circumstances, subject to the mutual agreement between the governing body and the state government. I would kindly appreciate altered, revised, or amended. And this is rescission. When alteration, revision, and amendment happens, it happens keeping the law alive. Because there cannot be any alteration, revision, or amendment in a dead law. It has to be alive. For that, the school's consent is there with the mutual understanding with the government, it can be done. But so far it is rescission. It is the power of the government to take back the law if it is not applicable anymore. And clause 19 of the rule supports the same because it says the school will follow any orders passed by the state government. So, my lord, it supports my contention that be it gazetted or non-gazetted, it is the power of the government to issue the orders. It can be an order itself. It can be an order itself. It's not required to be notified or rules, nothing. Even a simple order can be done. In our case, it is a notification rather. By the same authority, kindly appreciates my lord, by the same authority who had brought the special rules, both in the name of His Excellency the Governor, both in the name of His Excellency the Governor, both by the Joint Secretary, the rules were brought and taken back. And the clause 19 says, the school will be bound to follow all orders issued by the state governments. And the amendment of these rules, only the alteration is possible, not otherwise. Oh, sorry. Achha, my lord, a submission was made in respect of the section 45(1), 2D. My lord, it is out of context today. We have not challenged that. The rule-making power is already there. Your lordship has already recognized it. There is no point on that. 2D, 45, government has the power, government has done it. Now the question is whether whatever government has done is today is correct or not. I'm sorry, it is not even the decision of the government, whether it is there, it is existing or not today, the special rule, whether it has been rescinded or not. In that case, my lord, I would not waste your lordship's valuable time in referring to 45D because admissible position. There is nothing to say on that because the government has the power. The rule gives it the power. By exercising that 69, there has to be a coherence between the rules 1969 as well as the West Bengal Board of Secondary Education at 1963. So the coherence was there. That is why the rule has come into effect. And again, it has been taken back in its natural course. So, my lord, it has died its natural death today. So it cannot be resurrected today for the benefit of so-called self-styled minority institutions. Because, my lord, maybe pleased to recall, they have not received the certificate of the Minority Commission and they have not been allowed the minority status. Now, my lord, what will happen if today your lordship revives this law on this submission not published and all these technicalities and all? Now, there will be a substantial change in the status of the school, an undue advantage, which your lordship kindly recalls the Honorable Supreme Court and other coordinate and division benches have refused that you are not a linguistic or religious minority in state of West Bengal. You cannot have the access of the special rule. A Khalsa school may be a minority in West Bengal based on their religious ethnicity or their language. But you being a Gurukul Vidyalaya trust of the Arya Samaj, you have no status of a minority in state of West Bengal. So, my lord, if it is revived today, they get back their minority status. And when kindly recalls, my lord, the rule 33 of the management rules, today has ceased to exist. At this situation, if it comes back, there will be a catastrophic and cascading effect of that. Possibly here, the issue is very small, and the intention is to get it revived so that today a new class can be created, a new status can be created for them, which has otherwise been rejected by the government, by the single bench, by the division bench up to Supreme Court. It will have a catastrophic effect, my lord. The whole situation will be in turmoil because they will get, it means what? They will again get the status of a minority institution, which is otherwise not permissible under the 1996 of the Minority Commission Act. So revival of this will have some other more effect, which in our plain view possibly is not appearing before us today. But shielding this matter, there is a bigger intention of the institution or the class of institutions like that to get back that dead law alive and to get the control, which otherwise is under the government. So this is my submission. And I have already
Has
touched.
state filed any affidavit in opposition?
Yes. That contradicts.
Wherein they have stated that
Yes.
90s,
Yes.
1976.
Yes.
They have filed opposition. Their opposition, they have taken absolutely contradictory
But
stand.
you will find two affidavits in record. One was there originally at the time of the writ petition when it was moved. One affidavit by state is there, and subsequently also another affidavit state has given.
Now, my lord, only that state stand is absolutely contradictory. I again remind your lordship, maybe
No,
please
you have stated that
before the Honorable Supreme Court, Mr. H.K. Puri's submission, the then learned advocate of the state of West Bengal, that we are not accepting it as a minority. So, special rule, you may form your managing committee, but it will not, one. Secondly, the joint secretary, directorate, they issue the notification again. Let's see, this is the notification regarding their rescission of the law, and special rule does not exist today. Two. And thirdly, my lord, the honorable courts have already decided this issue, that it has been rescinded. So state today cannot take a different stand, telling one thing yesterday and telling something else today. Cannot be reprobate and approbate. And very surprisingly and interestingly, they say, yes, we are aware of the initiation of the special rule. We are aware of the subsequent amendment with the deemed provision, but we are not aware of the rescission. This is hilarious in my humble submission. It cannot be accepted. It cannot be before the court of law. With this, my lord, I conclude my submission, and I'm extremely grateful before your lordship for granting me this opportunity to appraise your lordship. I'm grateful to your lordship.
You have already asked me a state. Learned advocate for the respective parties have concluded their argument.
My lord, my notes of arguments may be taken.
Yes.
Notes of argument.
Well, I am for the state respondents.
Mr. Jana.
Well, Jana is not here. Well, can it be taken up next week?
I can say 24.
20. Very well. Very 24th month.
24.
Great.
Hyderabad 3.
It's an old matter. I am appearing for the petitioner. This writ petition has become infructuous.
Oh, that's Mr. Mukherjee, learned advocate, appearing for the petitioner, submits that with the passage of time, the writ petition has become infructuous. Consequently, the writ petition is dismissed can dismiss as infructuous, imprimatur if any stand valid.
I'm grateful.
Item of, item of 4.
চব্বিশ চব্বিশ চব্বিশ
But not there, it has been fixed on 24.
না
Okay. 24. 24. এটা আমার দাগ দিয়ে আছে কেন? November 2007.
কোনটা?
কত টাকা? 4 নম্বর।
4 নম্বর মিলট, 4টা তো আমাদের। 4 মিলট, I am the petitioner, that is infactual.
Huh?
Infactual matter.
Oh, it's same order. Same. Okay.
5.
I have same matter.
Yes. Same. It will be the interview. Okay. Same.
I declare.
6.
Recorded lawyer, eh?
Did it?
7.
Did it? Application আছে।
8.
Did it? Termination order. Application গুলো।
9.
Yes, you to say. Did it?
10.
Did it? Did it? Application আছে।
11.
Did it?
12.
DD.
thirteen,
Same.
14,
Same. DD.
15,
15, my lord, I am sent a letter to my client, my lord, whether he will proceed with the writ application or not, my lord. So I am seek 2 weeks time, my
2 weeks time.
lord. Yes.
Okay. 25th.
25th.
16,
Give lord.
My lord, I beg to appear.
At 16 minute, I am appearing for respondent number 1 and 3.
I am appearing for the respondent
2 and
10,
3.
right?
This is the affidavit in opposition, my lord.
I have filed my reply already.
Hard copy B, right?
You are for the school authority.
No, my lord. Respondent number 10, private respondent.
You serve the copy.
Yes, my
My
lord.
lord,
They are
I
not
served the copy upon the petitioner.
I have filed my reply, that is important.
We also something to respond.
Yes, my lord.
Huh?
Probably
You have
the,
challenged his appointment. At
no,
least
my
you
lord, I have
challenged his-
challenged
They have
Oh, you
I
have
am the college
challenged.
authority.
challenged.
You?
because
College authority.
College
I have
authority.
gone through the both the oppositions standard same.
My lord, but the opposition filed by the college authority has not been served upon me, right?
Then, my lord, I'll serve.
Okay, so sir,
And
In
my
the
lord,
course of the day.
meantime, I shall,
have you submitted reply?
Yes, my lord, that is in record. I have served the copy of the
Yes,
reply to my learned
I have-
friend also.
Do you want to use reply?
Yes, my lord. And
But
my
that is
lord,
not
reply
going to
and
change.
I also, my lord, may be permitted to file a written note of argument.
It's a very short matter.
The argument be completed. If requires, then you will.
Yes, my lord. I do not think the written notes of argument is required. My lord.
And we give my lord.
So what is the ground
Yes, my lord.
of challenge of his appointment?
Well, the
On
petitioner,
what ground you have challenged?
or the petitioner before your lordship participated in a selection process for the post of peon in
Peon.
2006.
In the college, yes.
Well, in that selection process, the private respondent number 10 come up with an order of this honorable court for participating because his name was not sponsored.
Answer.
The selection of the private respondent was challenged because subsequently it came to my knowledge that he has used a fake documents for the purpose of sitting or getting eligibility to appear in the selection process. That is the pleading in my writ petition.
You are the second name pen candidate.
No, the panel was not published. I didn't have the chance to go through the panel. All of a sudden, I came to know the respondent number 10 has been given appointment. But when I filed the writ petition with an alleged plea of that he has used a fake documents, he has been given approval of that appointment because this is a 2007 matter. But the private respondent has used an affidavit. Only turns to the affidavit filed by the respondent number 10.
Service regard. affidavit in opposition on behalf of private.
Private respondent number 3.
10.
Very short point involved. My lord, straight away turns to page 30.
Which, before that, kindly tell me which document was forged according to
Yes. Page 13.
page 13 of the writ petition.
No, page 13, the opposition used by the private respondent.
It is a joining letter.
No, my lord, page 13.
Page 13.
Pass certificate might be their wrong designation.
Certificate page 11.
Yes, pass certificate. Yes.
Yes, my lord.
That is
This is
8 pass certificate
8 pass certificate
issued by the
secretary or the headmaster of the concerned school, certifying, yes, Kevarakhali Nokul Sahadev High School.
Oh. Kevarakhali.
Yes, my lord. But here it states that he has passed class 8 examination in 1991. In reply, I have stated that the school, the certificate that has been used by the private respondent got his recognition is 1993. 1993. That yes, my lord. Because why I am so consolidated to this, because my lord, the private respondent and the petitioner were the student of the same school. That document I have also annexed. That document I have got from the
That
secretary.
is not the criteria. Whether he actually got admitted in the said school, or he was student of the said school, or he passed the class 8 from the said school or not.
Not quality text by affidavit in reply.
Affidavit in reply, yes.
Or reply. Reply to the affidavit in opposition filed by the private respondent. Page 10. I have annexed a recognition memo of the concerned school.
There is recognition memo, page 8. Okay.
Page 10, my lord. If I have correctly
That is
designated.
another aspect of the matter. That is going into another aspect. Whether the certificate issued by the unrecognized school would be treated as a valid certificate or not. That is another aspect. And one thing, whether in fact the private respondent passed class 8 from that school or not. Irrespective of the fact, irrespective of the status of the school.
A document which has been issued in favor of the private respondent, relying upon which he has got the appointment, the authority of the document or the veracity of the document I have challenged, that is my pleadings. And that has been corroborated by the document that has been annexed by private respondent. In response to that, I have annexed a document that appears at page 10. Secondly, my lord,
you take me to the notification issued by the school. School. Whereby application was invited to fill up the post. Have you annexed it?
Probably that is not. Now, kindly let me check. Or in addition to that, my lord, kindly consider page 12 of my.
Okay, I shall go according to your way, but kindly you answer the query.
One document that I have annexed.
Why I am asking the same? You try to read the mind of the court first to place. Whether in the notification there was a written that he has to pass class 8. He is to be a candidate, 8+ candidate from a recognized school or not. Whether there was such condition in the notification, inviting application
even if,
for the post.
Even if it is not stated in the advertisement or the notification, it is implied the school which doesn't have the any recognition, a student cannot get a birth certificate of the school and use that for getting an appointment. One more document
stated to be implied. It cannot be stated to be implied.
The qualification probably it is not with the writ petition. Probably the qualification pass eligibility criteria has to be 8 pass. the school which didn't have the, what should I say, didn't have the authority.
Learned Council, you kindly clear your stand. You have to take a firm stand.
Yes, my lord.
Your first stand is that the certificate used by the private respondent is forged. On hearing this, a mind of the prudent mind will say that he did not read and he somehow procured the certificate.
Yes, my lord. I'll kindly consider page 12.
Now you first ascertain whether he passed class 8 examination conducted by the school or not,
My lord, kindly,
irrespective of his status.
yes, my lord. I'll kindly turn to page 12.
12 of repetition.
No, reply. By reply.
Reply, affidavit reply to the petitioner towards affidavit filed respondent number 1 to 3.
No, 10.
10.
I have referred to page 10. Now I am referring page 12. That is a
12, yes.
because in the writ petition, I have specifically stated both of us were the student of this school, Jamtala, Bhagavan Chandra High School.
Yes.
It-
That means he read in this school.
in another school. This is a certificate issued by another school.
Bhagavan Chandra High School, yes.
Yes, my lord.
And he has used certificate of which school?
Yes, another school.
Kauratala.
Nokul Sahadev or Kaurakhali Nokul Sahadev school.
Kauratala.
That is my case. Because my pleadings,
There cannot be.
probably this certificate has been issued because he was overaged. Or in my writ petition, I have specifically stated both of us were the student of Jamtala High School. I have specifically stated in paragraph 8, page 10 of the writ petition.
Your date of birth is 19/10/1997.
1977.
1977.
19th October 1977.
The page 31 in your affidavit in opposition, it is appearing that the secretary of Kaurakhali Nokul Sahadev High School has written that date of admission was 5th June 1997. Date of admission. And date of birth 19th October 1977. That is in 10 years, you have got admitted in class 5 in 1987. And date of leaving 30th April 1991. Whereas Jamtala Bhagavan Chandra High School, its secretary, by issuing a certificate, says that you passed annual examination of class 9 in 1986.
My lord,
How?
just prior to that line, my lord, kindly see that my
The person who was born in 1977, one certificate is coming that he has passed class 9 examination 1986. That means in 9 years, he has passed class 9.
My lord, the certificate that has been relied upon by my learned friend, my lord, on appearing on behalf of the petitioner is not my contention. My lord, my humble submission is that, my lord, the certificate was issued by the secretary. Prior to that, my lord, the petitioner has filed an application under the Right to Information Act before the school authority as well as the college authority, relating to the point that whether I am a student, whether yes, I have been passed the class 8 examination, and what is my educational qualification. And my lord, that application was made in the year 2013. And my lord, I have been appointed in the post of peon, my lord, in the state college in the year 2006. And my lord, my service has been confirmed by the college authority in the year 2008. And my lord, he has made an application before the school authority as well as the college authority in the year 2013. Wherein, my lord, the school authority, that is my parent school, where from I have passed my class 8, that is the Keodakhali Lokur Sahadev High School, my lord. The headmaster on, my lord, 3rd April 2013, by a letter dated, my lord, 3rd April 2013, has specifically replied to the petitioner that as this is an exemption barred under the Right to Provision Act, as this information, whatever the petitioner is asking or seeking, that is a personal information, and as such it comes within the meaning of personal information. So this is an exempted category, and this cannot be provided to the petitioner. On 13th or 3rd April 2013, my lord, kindly note the date. And my lord, thereafter, the petitioner again in the month of May 2023, May, my lord, thereafter the petitioner somehow managed the secretary of the said school. And my lord, the secretary has issued this certificate, which is not at all, my lord, and which is not at all, doesn't have any.
Secretary of which school?
My lord, the school of
Jamtola.
Jamtola, my lord. The documents which he has relied upon. And my lord, the documents which he has relied upon, my lord, has been issued by the secretary, who has no authority to issue such certificate, because the secretary who has issued the certificate has not been implemented a party respondent in this petition, my lord. And my lord, his submission or his pleadings has not been verified by anybody. And my lord, the petitioner has already stated this, or has already admitted this in his writ petition, that my lord, he has received such information by himself from the office of the school. But my lord, if the school one on 3rd April 2013 has clearly stated that as this is the personal information and this could not be provided, how the school authority, how the secretary, being a member of the school authority, in contravention of its earlier decision, my lord, has issued another letter in the next month. My lord, both the letterhead, my lord, if your lordship kindly have a look, my lord, that is different. The documents which he has relied upon by the petitioner, which has been relied upon by the petitioner, is a manufactured one. The school pad. This is a type pad, my lord. The original pad, my lord, which has been suppressed by the petitioner, that he has annexed in the form of supplementary affidavit, my lord, which he has not, whether it is beyond my knowledge that whether he has used it or whether it has been placed before your lordship or not. So, my lord, all these things, my lord, all these points, my lord, I want to, my lord, place before your lordship in the form of, my lord, written notes of argument. And my lord, my service has been confirmed in the year 2008. 7, except my lord, filing a writ petition only in the year 2007, the petitioner has not taken any step. And my lord, in the year 2013, he has only made an application under the Right to Information Act, before the school authority as well as the college authority. But that has been rejected. Subsequently, he managed the secretary. And the secretary has issued the letter in a manufactured letter paid
You
by.
passed Madhyamik examination also.
No, my lord. Yes, my lord. On the date of my pass,
From which school you appeared in Madhyamik
my
exam?
lord, I have passed my Madhyamik as well as my higher secondary from the higher secondary examination, my lord, from the Ravindra Mukta Vidyalaya. And my lord, all these documents I have already.
Not from Jamtala.
No, my lord. And my lord, the statement made by the secretary.
That means after passing class 8 examination, you left, you drop out.
My lord, I left the my lord.
They left the school
School, my lord, and my lord, I got
and study also.
Yes, my lord, I got admission in the Ravindra Mukta Vidyalaya, my lord, due to my poverty and my lord other things, my lord. And all the original documents I have with my custody, my lord. And my lord, the secretary, my lord, kindly have a look at the statement of the secretary. That, my lord, in the year 1984, I was a student of class 8 and I passed the class 9 examination in the year of 1986. And my lord, in the writ petition at paragraph 8, my lord, the petitioner has admitted that both of us, that means the petitioner and my lord myself, were the student of the said school of Jamtala. And my lord, I passed the Madhyamik examination in the year 1988.
88, yes.
That means, my lord, the 2 years gap. As per the version submitted by the petitioner, submitted by the secretary, the documents which has been relied upon by my learned friend appearing on behalf of the petitioner. That, my lord, I was a student of a Jamtala school in the year 1984. And my lord, I passed the class 9 in the year 1986. And my lord, at paragraph 8, my lord, of the petition, the petitioner has admitted that I have passed the Madhyamik in the year 1988. My lord, this is totally a manufactured document, my lord. Totally a manufactured story, my lord, placed before your lord. Just in order to, my lord, disturb my service, my lord.
In 86, if you pass class 9,
Yes.
87 will be exhausted for class 10.
Yes, my lord.
Then in the month of March or February, the Madhyamik Parikha will be 88.
No, my lord, if I am a student of class 86, my lord, 84,
86 is past the annual examination of class 9.
yes, but no, my lord, as per the statement made by the petitioner, my lord, made by the secretary.
Who is appearing for the state?
That, my lord, I was a student of class 8 in the year 1984. And, my lord, the next line kindly happens, my lord, that I have passed the class 9 in the year 1986.
What is the stand of the school authority?
His college.
I'm for the college.
College?
College, my lord, the entire.
Have you got the police verification report?
My lord,
Have
kindly
you
come to.
have you considered the police verification report?
My lord,
Police,
kindly
any
come
police
to.
verification report, everything will be reflected.
My lord, kindly come to page number 31.
31 of your affidavit.
Affidavit in opposition. My lord, there is a one mistake in my affidavit in opposition. Where my lord, I have written that respondent appearing for respondent number 1 and 3. It should be 2 and 3, my lord. Not 1. 1 is the statement. My lord, liberty may be granted to.
Okay.
It's 2 and 3, not 1 and 3. Page number 31 of my opposition.
Kultoli Dr.
It is written by the teacher in charge to the government of West Bengal Department of Labor. The verification of
verification of qualification and date of
qualification
birth.
and date. But here date of admission is
Employment officer in charge, district employment office.
yes.
Okay. Government of West Bengal, Department
yes.
of Labor, district. Here,
The date of admission
who has submitted such
as teacher in charge, my lord, to the
teacher in charge
employment.
of
The date of admission, my lord, on 15th of June 1987. Whether admitted on transfer, that is South Keorakhali FP School, class which admitted, that is in class 5, date of birth as per registration 19th October 1977. Valid proof of age produced at the time of admission is 9 years, 7 months, such and such, and date of living on 30th of April 1991. And the class in which he was reading at the time of leaving, that is class 8. Last examination, class 8.
So, page 31,
But how could he certify this? Because the school didn't have the recognition at that material point of time.
that is another
Well,
aspect.
that
of
is
the-
my all along argument before your
No.
lordship.
In that circumstances, you should have make out your case or make submission that the certificate issued in favor of a candidate by one in unrecognized educational institution is bad, cannot be accepted. That is another.
Malado. At the time of,
Now, so far, we waste our judicial hour
kindly appreciate.
in making an investigation as to whether this person actually got admitted in what school, Kaurakhali
Kaurakhali local school.
or not,
The
or whether this person passed 8 examination from that school or
Malado, kindly do appreciate. Malado, the page 10 of my reply, I have annexed a document. That is the document of the government. Wherefrom it would be evident that the school got a recognition in 1993. And that document I have got subsequent to the filing of the writ petition. So in my writ petition, that story I cannot develop, my lord. I couldn't develop.
so the certificate issued by the Jamtola school has got no validity.
Assuming that. Well, assuming that.
You
Not
have
that-
created confusion.
Not kindly.
No, it
appreciate.
would be why the writ petitioner will not be penalized.
Well,
You
kindly-
have got a certificate from the Jamtola school, and if the attendance
well, keeping aside that aspect.
if the admission register or attendance register of Jamtola school does not reflect that this student got admitted in Jamtola, then why the writ petitioner will not be penalized?
My lord, in that event, my lord,
Submitting misleading certificate.
my lord, in that event, my lord, kindly grant me leave to add Jamtala High School and call for the record. Not because the document that I have annexed in my affidavit in reply, page 10 of that, it clearly says the school didn't have the recognition in 1991.
Oh,
My lord,
you again force
Lord,
enforcing the code.
oh, no, my lord. My lord, this is my humble
Yes,
submission. I'm not.
Now you developed your case, forget about. You accept that this person passed class 8 from Kaurakhali school. Now you make out your case, you tell that the certificate issued by the unrecognized school is bad.
Oh,
Now, you
My lord, kindly allow me to.
yes.
My lord, my contention in the writ petition, I cannot change my stand that he was a student of Jamtala High School. I cannot change my stand, my lord. And at the time of participating in the selection process, he has used a document of a school that school didn't have the recognition. Because I have stated on oath that he was a student of that particular school where I was one of the students.
So if your first point is accepted, there is no requirement to take any decision on the second point.
Because,
If he is not at all student of Kaurakhali,
yes, my lord.
so why court will waste time in making judicial
Yes, ma'am.
determination?
Well, because-
that whether
Because he has got appointment relying upon that.
recognized or not recognized, that
Or
is not required.
My lord, kindly appreciate. He has got appointment relying upon that particular document. That is
Kaurakhali.
admitted. Yes.
Kaurakhali.
Yes.
So you tell he was not student at all of Kaurakhali.
Yes.
And my lord, my service has already been, my lord, I have already in service, my lord, near about 2 decades. That means, my lord, 18 years have already elapsed, my lord. And my lord, it is now a settled proposition, my lord, in terms of the authority passed by this honorable court, my lord, as well as the by the honorable apex court, my lord, that my lord, the settled position should not be unsettled. That means, my lord, more than near about, my lord, 2 decades I have been in service. And my lord, I have been in service.
When you got service?
Yes, my lord, I have been joined in service in the year 2006. And my lord, 2006, my lord.
6. The writ petition was filed in 2007.
Yes, my lord, my service.
So
has-
don't think they 2023 it is pending.
No, my lord, my lord, my service has been confirmed with the college authority in the year 2008.
Although there was no order and the writ petitioner has not sought for such order from the court, but it should be impliedly, it implied that your appointment,
The secretary-
confirmation, everything subject to the result of the writ petition.
Yes, my lord, the secretary of the Jamtala High School, my lord, who has issued this purported certificate, my lord, should be implemented, my lord. My lord, kindly direct the secretary of the Jamtala High School to be implemented as participant.
So in the circumstances, the secretary of the Kaurakhali school should also be implemented.
Yes, my lord, he has been implemented.
He is a party.
He has already been implemented in this proceedings, sir, before your lord. 9. My lord, respondent number 9. But my lord, the documents relied upon by my learned friend, my lord, on behalf of the petitioner, my lord, has not been implemented. And my lord, in paragraph 8, my lord, he has already stated, admitted the fact that he has received this information by himself as well as from the office. And my lord, the right to information application, my lord, he has completely suppressed before your lord. That he has made an application under the Right to Information Act in the year 2013, and that has been rejected by the school authority as well as by the college authority. And my lord, thereafter, my
That
lord,
would be proper, or I shall ask the state. Mr. Chatterjee, you are going to another court. You appear in this matter, and here is a college matter, so director of public instruction would be the appropriate party. Joint director of public instruction has been made party. It would be better you send the joint director of public instruction or any competent man who will attend both the school and make an inquiry. He will peruse the admission register, attendance register of the school, and come out a decision whether the writ petitioner was student of Jamtala or student of Kaurakhali.
The matter may be delegated to the director of public instruction or the joint director of public instruction. To hear both the parties and consider the relevant documents.
That would not be.
the college authority has already, my lord, filed their report, my lord, before your lord.
College authority.
Yes, well. This is my learned friend.
I am asking the report from a impartial authority, that is the state. One responsible officer will go, he will visit both the school, and he will peruse the admission register, attendance register, whatever the document of both the school, and come out with a report, and he come out with a fact and submit a report before the school. Whether the private respondent passed class 8 examination from Kaurakhali or he passed class 8 examination from Jamtala. Inquiry report.
Detailed inquiry.
My
My lord, kindly direct the college authority to serve the copy of the affidavit in opposition.
you, sir. Affidavit in service on behalf of the college authority is kept with the record. Yes.
Granted, my lord, to correct the front page, my lord, on behalf of respondent number 2 and 3, not 1 and 3.
In the cost title of that affidavit in opposition, it has been erroneously written that the affidavit has been used on behalf of respondent number 1 and 3. Respondent number 1 is the state, and hence the learned advocate representing the college authority pays for leave to make necessary correction of the cost title of this affidavit in opposition. Such leave is granted. The learned advocate.
My lord, I'm sorry. I'm praying apology, my lord. My lord, in the writ petition, my lord, because it is in my opposition reply, it is state of West Bengal, but in the writ petition it is stated Kultoli Biarambel is respondent number 1. I'm right. Kindly see page number 3, my lord.
Okay.
And my lord, leave me
Okay, you
to
have
me, my
seen-
lord, for filing the reply, my lord, in respect of the affidavit in opposition
Page
filed by
number
the college.
3, 1. They're all proper.
That would be given. Don't worry. Scott, here, This writ petition was filed challenging the appointment of the private respondent number 10 in the post of peon in the college. The writ petitioner raised the issue that shortly put, the issue is as to whether the private respondent passed class 8 examination from Kaurakhali Nokul Sahadev High School, or he passed that examination from Jamtola Bhagavan Chandra High School or not. The writ petitioner, in the writ petitioner, it was urged by the writ petition that the certificate issued by Kaurakhali Nokul Sahadev School in favor of the writ petitioner is forged. Writ petitioner is forged. The writ petitioner had never got admitted himself in that, never admitted himself in that school. Never got admitted in the school. Rather, he had his schooling from Jamtola, such and such. I need to dekhe neben, Jamtola High School. Jamtola Bhagavanpur High School. And the additional issue he has taken, additional point he has taken in this petition, that at the time of issue of such certificate in favor of the petitioner, the Kultoli Nokul Sahadev School was unrecognized school one, and hence the certificate issued by one unrecognized educational institution cannot be treated as a valid, and basing upon such a certificate, no valid appointment can be given. Stop. Since one confusion has been created whether the writ petitioner passed class 8 examination from Kaurakhali school or from Jamtola school, I am of the view that a report from an impartial authority will assist this court in giving judicial answer to this query. Stop. At the time of hearing, none representing the state. Stop. I found Mr. Chatterjee, who usually appears on behalf of the state, is present in court. I request Mr. Chatterjee to appear in this matter and to avail necessary instruction. Stop. Stop. Appointment of Mr. Chatterjee be regularized. Would you be able to submit a report, or by expressing the mind of this court, that court has, or I shall pass necessary direction upon that?
Madam, the secretary of the Bhagavan Chandra High School, madam, could be included as a party.
I am not keeping at the secretary level. Okay, I am going to direct or public instruction. In such complex and chronological events, I am inclined to direct the respondent number 7, the Joint Director of Public Instruction, Education Director, Government of West Bengal, to make inspection of both the schools and to peruse the admission register as well as attendance register of both the schools, and to unearth the fact from which school the private respondent, namely Sri Madhav Chandra Haldar, passed class 8 examination. Such report must be submitted through Mr. Chatterjee within 3 weeks, within 3 weeks from date. ঠিক আছে? আচ্ছা, let a plain copy of this order be handed over to Mr. Chatterjee, who is requested to communicate this order to the respondent number 7 for his information and compliance. ঠিক আছে? List the matter. Server copy. ঠিক আছে। আচ্ছা, আচ্ছা, আচ্ছা। হ্যাঁ? List the matter 3 weeks since.
And ballot, in the meantime, I shall file the reply.
But in view of this fact, all of you have to serve the copy of your respective pleadings to Mr. Chatterjee.
Yes, madam.
Okay? All of you.
Ballot, kindly incorporate.
Acha, all the party, the writ petitioner, college authority, and the private respondents are directed to serve the copies of their respective pleadings along with all annexures thereto to Mr. Chatterjee in course of
This week.
Acha, by tomorrow.
This week.
Okay? Tomorrow.
Ballot,
ঠিক
within
আছে।
this.
Is the matter for further consideration 3 weeks hence.
Ballot, kindly fix the date, while.
3 weeks হয় তো?
3 weeks মানে কবে? আজকে কত তারিখ? First. Last day
Last
of this month.
Grateful.
What will be your fate will be decided. Okay.
Ballot, I am confirmed.
Okay. If anything wrong done by you, I shall not leave you.
No, my lord, I am confirmed.
Okay.
Grateful.
And if these answers come, then we shall find the answer of your query, whether the certificate issued by the unrecognized school would be valid or not. Okay, one by one.
And my lord, regarding this point, my lord, I shall also give the reply. I shall.
Okay, you are at liberty. The petitioner is at liberty to file his reply to the affidavit in opposition used on behalf of the college authority.
My lord, petitioner, I am.
Private respondent, sorry, private respondent.
Yes.
Private respondent is at liberty to use submit his reply to the affidavit in opposition used by
The college authority.
the college. Next.
Matter 17.
Group C,
17.
4th May 2007. Group C, 4th May 2007.
18.
Do one matter yourself before the court. Always you pray for time. Please do matter before this court. I am here. Okay, I shall not attack on every step. Okay, you proceed. Where is your beef? Come tomorrow, you will do it.
My lord, last occasion, your lordship has directed me to file an affidavit in opposition. Opposition is ready, my lord. Kindly, my lord, 10 days time may be extended for affirmation, my lord.
Then again, he will say, I shall file a reply. Huh? We want to use opposition. Item number 18. The matter was filed in 2007.
2007, my lord, in spite of direction of,
Only 16 years ago.
my lord, this is
And
not,
the boy who born when the matter was filed has passed.
they have
Madhyamik
filed
examination.
thereafter 6
Now he is a student of.
No, my lord. Your lordship is directed to file the opposition of the application, which is filed, my lord, in 2023, November, my lord.
Oh, application.
Yes, my lord. For opposition of that
There
application,
are 3 applications.
6 application was there. Your lordship was last occasion disposed 3.
Okay, I am fixing on 25. Do whatever you like.
My lord, they are not paying.
Without electricity, 16 years you are living. Huh? You have become habituated in living without electricity. So don't come out from that habit. You are living without electricity in this age and for 16 years. Your example. Don't require. Electricity is not required for your better living or
Providing electricity one bulb in each and every Ujala.
yes.
16
years. It is Union of India and others.
Yes, my lord, I am for the respondent, my lord.
Union of India does not give us electricity. It is our state and west distribution. Metro rail. You are taking electricity from metro rail. Okay, yeah, 25. Come on, 25. Do whatever complete readings in the meantime.
And my lord, kindly extended that time.
You file, it would be accepted. Okay. Yeah. Yes.
19.
I am for the state proceedings.
I'm for the petitioner before Lordship. My Lord, that matter, Your Lordship, with regard to pass certificate, the original pass certificate I could not produce before the authority concerned. And
at the time of when interview was taken?
At the time of filing of my application. The time of filing of my application. And since only 2 persons are there, my application was rejected. So one-man panel was prepared and appointment was given. But unfortunately, the private respondent has expired soon after few years. And the petitioner is there. He's pursuing this application. Your Lordship has was pleased to direct me to serve copy. So he served the copy.
I have brought the legal heirs of private respondent number 6 on record.
Yes, Your Lordship, pursuant to court's order, Your Lordship.
It's a personal action one. Whether he will get job or he will get job, it is the issue.
This is not at all required. Because it's not the property of
actually cause of action does not survive to private respondent in respect of service related matter.
Service related matter. And there is no scheme for compulsory appointment also.
Yes. Okay, you have brought.
Yes, Lordship.
Now tell what is the case.
Yes, Lordship. My Lord, pursuant to an advertisement that is at page 26, P2, dated 16/12/2006. My Lord, interested candidates are being invited to make application for appointment.
Additional para teacher.
Additional para teacher.
Yes.
And petitioner before Lordship, as he passed his geography, in the year, Your Lordship, this is at 2005.
If 2005, you completed graduation.
Yes, Lordship.
In geography.
Geography.
Yes.
And I participate out there. And while making the application, my Lord, we had given a provisional pass certificate along with the application. And my said application was refused by the authority concerned. It was not accepted only for the reason that I could not produce the original pass certificate along with my application. Especially for the reason that I did my graduation from outside West Bengal, because I did my graduation from
Murmu University, Dumka, Jharkhand.
Yes, Lordship. Sidhu Kanhu Murmu University, Dumka. My Lord, I made a representation before the authority concerned. This is at page 27. The next annexure, Your Lordship, wherein we have requested the authority concerned to accept my application with an undertaking that as soon as I will get the original pass certificate, because it is it is a general custom, rather, this is the fact that after passing the exam, to obtain the pass certificate, we get it after 3-4 years. And this is only I passed in the year 2005, and the very next year, Your Lordship, I made this application. The proceeding is there. So I requested them to allow my application, to accept my application, and with an undertaking that as soon as I obtain the things, and if I succeed in the things, that I shall produce the original pass certificate before the authority concerned. But they did not do so. My lord, my application, my lord, thereafter, কেমন করে গেল? And Your Lordship, one-man panel was prepared and appointment was given to that person. My lord, initially we filed an application challenging that said action on the part of the respondents, which was registered as WP 855 W of 2007. This is at page 33, Annex P5. And this Honorable Court directed the authority, my lord, to consider my representation and to pass a reasoned order therein, to consider and dispose of the above representation of the petitioner in accordance with law within a period of 6 weeks, and that is the direction. And pursuant thereto, my lord, at page 36, my application was considered and rejected by the Office of the District Project Officer. That is at page 36. You have challenged this order. My lord, kindly look into this. The order impugned here.
I have looked.
Yes, Your
You
Lordship.
could not produce the original certificate at the time of
That is the reason, Your
submission of
Lordship.
school. Therefore, his candidature will be
Yes,
worse.
that is the reason, Your Lordship. But I did have the original mark sheet with me that I produced. I did have a copy of the provisional certificate, pass certificate that we produced.
Provisional certificate was also issued in 2007. Provisional certificate was issued date 8 January 2007. On which date interview was taken?
The date of submission of document was last date was 26 December 2006. Page 26 bottom. The advertisement shows that the candidate
2006.
Yes.
2006.
26 December.
Yes, Your Lordship. No provisional certificate is there. Because the application is there. Application is at page 30. It contains the documents that we had submitted without provisional certificate, pass certificate. But I did have the mark sheet. Original mark sheet was with me. That was produced and submitted before the authority. Well, this is at page 30.
It is their discretion whether they will.
No, this is a temporary appointment. Can you kindly have a look into the advertisement? অস্থায়ী রূপে চুক্তিভিত্তিক appointment, not page 26. Totally, my lord, 1 year appointment. My lord, kindly have a look in the advertisement. সর্বশিক্ষা মিশন মুর্শিদাবাদ. Third line. Such and such মাদ্রাসা সমূহে সম্পূর্ণ অস্থায়ীভাবে চুক্তির ভিত্তিতে 1 বছরের মেয়াদকালে এতটি শূন্যপদে অ্যাডিশনাল প্যারা টিচার নিয়োগ করা হবে।
My lord, all these appointments that's being made subsequently, it's still continuing.
No cause of action.
Still continuing. No cause of action. My application was
zone of consideration.
How could that be, Your Lordship?
Not produce the certificate. Even my lord is rightly pointed out provisional certificate. And my lord, 2000 since 2010 April, total appointment, my lord, is stopped because that scheme has been my lord, gone into an end.
My lord, Your Lordship would be kind enough.
My lord, petition became infructuous because my lord, he did not come with the zone of consideration. Is it total?
Why not, Your Lordship?
My lord, temporary appointment for 1 year, he could not satisfy. And
what could not satisfy? My application was not wrongly considered by the authority concerned. Your Lordship would kindly, Your Lordship, look into the advertisement. My lord, everything, the authority concerned shouldn't be allowed to act beyond what is stated in the advertisement. advertisement doesn't speaks of anything like that, that I have to
Certainly,
get,
my lord,
I have to get for participation in the said proceeding, I have to get the original pass certificate. Nothing is there. My lord, I'll place it before lordship.
my lord, it appears that my lord, the advertisement, my lord,
My lord,
উচ্চ প্রাথমিক বিদ্যালয় মিডল পোর্শন মাদ্রাসা প্রার্থীকে সংশ্লিষ্ট বিষয়ে স্নাতক হতে হবে, বিএড বিটি সংশ্লিষ্ট বিষয়ে সাম্মানিক স্নাতকোত্তর প্রার্থী মালাট the outside the state, the malar unless the provisional or certificate is been produced, malar marksheet would not be taken into consideration.
Let my learned friend show that. Let my learned friend show that what my learned friend is showing.
The point of maintainability, because he it is a temporary appointment. He do not have malar next year. Malar he did not come into zone of consideration. He do not have any local standard to challenge. Subsequent
My application
professional certificate subsequently produced.
My application being considered wrongfully, rejected wrongfully and arbitrarily, and rather you could say illegally, only for the reason it is not stated out there that for this reason, if I am not in a position to produce the original pass certificate, my application will not be considered. It is not there in the advertisement itself. My lord, the authority is not in a position to act in divorce of what is stated in the advertisement.
Not any
It simply speaks of that I should be
appointment for 1 year. 1 year gone.
Well, that appointment subsequently is still continuing. It's not only for 1 year. Initially for 1 year, but that appointment was continuing. It's still there.
From where?
All the person who got appointment in the year 2005, 2006, they're still acting as
2010 April, government issued a notification, government order that henceforth no para teacher would be appointed because central has stopped this scheme.
I am not.
Those persons who got their yearly renewal of contract from the madrasa authority or school authority, they are entitled to complete the 6. Next day I will produce that geo. But my lord, I request my learned friend to produce your lordship that next year or whether 1 year appointment selection was done, whether second, third, fourth year he did not challenge, and even in the present he do not have any interim order.
What is it? I have to come everywhere challenging the action on the part of the state.
Person concerned, panel goes after expiry of the person concerned,
but
the appointed person has expired. Panel goes. Because it's not only permanent, it would not be open for last 16 years. That panel would be kept alive.
What panel, your lordship, is my candidature. My application is pending. It has not. Let him complete this. Let him complete.
He has not. I am not completing. I am assisting.
The problem is that first, it is subject to what you will submit. It is their discretion of the interview board or the person who constituted the board, interview board, that they have not given you the opportunity to accept your undertaking and to produce the certificate at that date, only at that date.
My lord, I would submit your lordship that
is their discretion.
That can be the
that apart, they initiated the selection process. What they have done afterwards, that is another aspect. They initiated selection process to engage a person for 1 year in the year 2006.
That's not true.
Now, whether at this stage it would be justified to ask them to accept your candidature and to appoint you in that process.
Why not, your lordship? One thing, your lordship. First thing first. Your lordship said that, opined that there's a discretion on the part of the board. But that can't be. The board is bound and entitled to proceed on the basis of what is there in the advertisement.
Advertisement, there is no how they will be satisfied. In the advertisement, they have stated that your educational qualification is to be graduate.
Though they ought to be satisfied with that only.
They will satisfy themselves that you are graduate on the basis of your mere mark sheet
Yes,
or certificate issued by a recognized university.
my lord. After passing in the year
And that court
2005,
direct that yes, you are bound to be satisfied only on the basis of the certificate mark sheet,
my lord,
and it will not. You are not allowed to ask for certificate.
it's not that. I had given the undertaking. I have given the undertaking. First thing, your lordship, that they're not in a position to act arbitrarily. What they are entitled to act strictly and strictly adhere to the advertisement. Whatever is there in the advertisement, they ought to strictly adhere to it.
Advertisement is silent.
So silent, so they have to accept on that.
When there is a silent, when advertisement is silent, that means a greater discretion has been given to the interview board. How they will satisfy themselves, it is their discretion.
My lord, satisfying, my lord, I produced before them the original mark sheet. It's not a photocopy of it. I had produced the original mark sheet. I had requested them. The other, my lord,
Even if it
kindly,
is
my lord,
held that they are committed mistake,
my lord, kindly, your lordship,
not placing their reliance on the mark sheet submitted by you, but facts remains that the selection process was initiated to fill up, to engage a person for 1 year.
subsequently those,
Can the court force that you engage? 1 year has already been
my
expired.
lord, subsequently that appointment of 1 year, temporary
What?
appointment, has been extended, and all those persons,
That means the person, the engagement of the person has been extended.
yes,
Engagement of that person,
yes,
particular person,
yes,
that particular person,
yes, it's not particular, all the person.
or the person was engaged.
Yes,
What engaged as para teacher in the school are extended. Their
Yes, Your Lordship.
engagement are extended.
yes, your lordship.
But here there is no engagement at all now. After death of private respondent,
Yes.
whether they have decided to
This my application, this is all of your lordship to decide it. If my application, my lord, if
cannot say anyone you engage.
it's not
It
the
is
question
their
of engagement, let them consider my application. My application is there because after your lordship, if your lordship find this order that's been passed by the authority concerned, dated, copy date, copy, 15,
You could
15,
not produce
5.
the certificate. You
My lord,
could not
that is it.
produce the
If this is, if
his
this,
original certificate at the time of submission of
if yes, your lordship, if this order is, if this order, if your lordship find is not, it's arbitrary. Your lordship is
why arbitrary?
arbitrary because there is no reason. Lord, is it the reason, your lordship, for merely not producing the original pass certificate?
Failure on your part to produce the
Failure
original
is
certificate
because it is not
before the
possible.
interview board.
Because it is not possible for a person to produce a pass certificate after passing 1 year of the exam. It takes minimum 3 years to get the original pass certificate. 3 years you get, a person gets. My lord, we after passing the law exam, we obtained a pass certificate after 5 years.
We got provisional certificate.
Yes, definitely.
But that was also not produced. This is not a
Provisional at that. This is before the authority, my lord. Before, my lord, on 15/5/2007, we did produce the provisional certificate before the authority concerned.
Interview over.
Interview over. That is, I'm not making any denying that, but my application was not considered. If I was within the zone of consideration, my lord, wrongly they refused to consider my application. They considered an application of a person having geography not as a main subject also. I was the only person having geography as my main subject in the graduation. Well, can you look into my mark sheet?
But that issue has been decided in earlier read petition, page 34. My lord, he did not raise these points in the earlier read petition. Nothing has been.
It was directed to be considered. It was directed to be considered.
The submission of the petition has been recorded, page 34.
Yes.
Wherefrom it appears that person is without having certificate got the appointment. Nothing has been, new case has been made out there here.
New case?
Give me some handle, learned advocate for the petitioner, learned counsel. whereupon I shall assist you.
My lord, what we have stated before lordship is this, what have we prayed, that let this order impugn be set aside and direct the authority concerned to consider my application.
It was on earlier occasion, this court directed.
Yes.
After,
That
my
they
lord,
have stated that you could not produce.
with a finding, your lordship, if your lordship makes a specific finding that mere non-productions of original pass certificate within 3 years of passing of the examination, my lord, my application before the authority concerned by order dated 15/5/2007 shouldn't have been dismissed, or shouldn't have been considered. At that point of time, my lord, I produced the provisional pass certificate. I do have the original pass certificate with me right now. I do have.
Only issue of non-production of original certificate. In the earlier writ petition, it has been recorded there. Only this issue. This issue has been decided. Yes. He failed to produce the certificate. Without certificate, the mark sheet would not be taken into value.
Before the authority on 15/5/2007, I did produce my provisional pass certificate. I did. It's not that I didn't.
Not at the time of interview.
I couldn't because I didn't have.
This is fault.
I didn't have. Or my fault, your lordship, is not.
Actually,
It's not my fault.
Where original pass certificate is required to be produced in respect of that selection procedure,
It's not
you
there.
will be acquired eligibility only upon receipt of such certificate.
Yes.
Not before that.
Grateful, madam.
It is not
Because
there.
you are not able to produce the same.
But lord, this is not there in the advertisement. Can you look into it?
I am saying advertisement is silent.
That means, my lord, that means,
Sort of advertisement
my
is
lord,
silent, then a discretion is given to the
my lord,
selection
then, my lord,
committee.
my lord, then, my lord, all the persons who passed their examinations in the year 2005, 6, or 2004 even, then they wouldn't have been made eligible to appear before for the selection proceeding.
Certainly.
Because most of the person,
If the employer makes it production of original pass certificate makes it mandatory.
they should have been stated.
If the
It should have been
employer
stated.
thinks that its production is mandatory, then he will not acquire eligibility.
My lord,
But he was not
my
called
lord,
for the interview also
this-
because my lord, on the scheduled date he could not produce that. That is why he was not called for.
my lord, it should have been stated in the advertisement.
He has
My lord,
stated
I'll come up with the finding of the Honorable Supreme Court as well as of our court, that you cannot go beyond what is stated in the advertisement.
It
cannot.
is settled. It is settled.
So
So
if
why-
there is no statement with regard to production of
why
pass
It
certificate,
has been stated that they will satisfy themselves with the certificate and they will not insist on production of original certificate, pass
it
certificate.
is not here. So what is not here, they can't do anything. They can't go beyond this this advertisement. This is the specific finding of the Honorable Supreme Court as well as by this Honorable Court. This is a general principle.
Only my lord, a temporary appointment for 1 year.
What
This is
temporary
whether he was
appointment,
called for
whatever,
interview.
my lord,
That is
an
the
appointment is
other
appointment.
interview.
All the appointments are temporary.
He-
All the appointments
was
in the
not
world
called
are being
that is
given a
what
temporary
he was-
appointment.
He has not challenged that.
No one gets permanent appointment at the initial stage. All the appointments are being made temporarily.
That person's accrued that right. He do not have that right. He was not selected. Grateful.
My lord, we'll come then with the findings of the administration. Kindly, your lordship.
Come
My lord,
with-
kindly.
come with a better case. Achha. Questioning the sustainability of the order passed by the district project officer SSA Murshidabad dated 15th May 2007 in deference to the order passed by a coordinate bench of this court on in 19/3 2007 in WP number 855 within bracket W of 2007 and seeking a direction upon the concerned respondent to consider the case of appointment of the petitioner in the post of additional para-teacher for male in geography in Bokhara, BOKHARA, Haji Jubed Ali Vidyapit, within brackets, in short the school, comma, this writ petition was instituted. Stop. Briefly stated, the facts leading to this petition is that a selection process was undertaken by the district magistrate and Murshidabad and district project officer Sarva Shiksha Mission Murshidabad for giving engagement in the post of additional para-teacher for male in geography in the school. And the vacancy was notified by a notification by number 3 of 2006, dated 16/12/2006. ঠিক আছে? Vacancy আচ্ছা, inviting application from the eligible and intended candidates for the post. Stop. In the notification, it was specifically mentioned that the essential qualification of the candidate who will offer his candidature for the post is that the candidate must have to be graduate on the relevant subject. Stop. In response to that notification, the petitioner, by making an application, offered his candidature for the post. But at the time when his candidature was considered, he could not produce the original pass certificate showing that he had essential academic qualification for being engaged in the post. Accordingly, his candidature had not been considered. Stop.
But he had produced the mark sheet, original mark sheet.
আচ্ছা, তাহলে আগে লিখবেন, he produced the mark sheet, but he produced the mark sheet, না তার আগের লাইনে, could not produce the certificate. He produced the mark sheet but could not produce. He produced the original mark sheet but could not produce the original certificate. ঠিক আছে, stop. কি বললাম? লাস্ট লাইনটা বলুন, লাস্ট। Consider and a single man panel was prepared and the private respondent, since deceased, was given such engagement. Stop. Since the representation, stop. In view of such fact, in such conspectus, the petitioner made a representation on 30th December 2006, but despite receipt of such representation, the same was left unattended, and hence the petitioner was compelled to approach this court by preparing a writ petition being WP number 8585, এটা কি 4 or 9? দেখে নেবেন একটু দাঁড়ান। 855 within bracket W of 2027, which was disposed of by a coordinate bench of this court by directing the respondent number 2 therein to consider and dispose of the petitioner representation in accordance with law within a specific time frame. Stop. Pursuant thereto, a reason order has been passed by the District Project Officer SSA Murshidabad on 15th May 2007. Stop. Whereby it was wherein it was specifically stated that since the petitioner could not produce its original certificate at the time of submission of his application, his candidature for such engagement had not been considered. Stop. The order passed by the district project officer on 15th May 2007 is under challenge in this writ petition. Stop. Mr. Hawk, learned advocate, appearing for the petitioner, submits that facts remains that petitioner graduated with geography, as main combination subject from Sidhu Kanu. From Sidhu Kanu Murmu University, Dumka, Jharkhand. He submits that he contends that he produced the original mark sheet, but as per the rule followed by the said university, the pass certificate is issued to all candidates 3/4 years after completion of examination. He submits that even in 2007, even he gave undertaking for production of such certificate immediately on receipt from the university, and even in 2007 he submitted provisional certificate, but his candidature has not been considered for such engagement, and he submits that the employer is bound by the terms and condition of the notification, and hence the authority concerned has acted illegally in not accepting that undertaking and in not placing reliance upon the original mark sheet which was produced by the petitioner at the time of submission of his application, and he submits that appropriate direction should be given upon the concerned respondent to give such engagement to the petitioner. So, Mr. Chatterjee, learned advocate, appearing for the state, or you are representing all?
Yes, madam.
Respondent, no.
Not all, because I am not the
Respondent number up to respondent number 1 to 3 korbe. Up to respondent number 1 to 3.
1 to 3.
1 to 3 submits that the selection process was undertaken to give engagement in the post for only 1 year. that 1 year has already been lapsed. ঠিক আছে? And it is and there is no quarrel in accepting this fact that at the time of submission of his application, the petitioner could not produce the original pass certificate. He submits that by passing a reason order, the district project officer has rightly negated the claim of the petitioner claim and rightly rejected his representations. He submits that there is no scope of interference in the writ petition. Stop. In response, Mr. Hawk submits that the engagement which was given in the post of additional para teacher has been extended from time to time, and now, as per the rule, extant rule, they will not be disengaged until they attain the age of 60. He submits that considering this aspect, the respondent should be directed to consider the candidature of the petitioner for such engagement. Stop. Heard the learned advocate, perused the materials placed before me. Stop. Acha. In the notification dated 16/12/2006, the essential academic qualification was prescribed. It was prescribed as essential qualification. It was prescribed that the candidate offering candidature for such admitment must have passed. Offering candidature for such engagement must have to be graduated. Achha. And there is no specific instruction contained in the said notification how the person who will examine the candidature of the candidates will be satisfied regarding the educational qualification of the candidates. It was left at the discretion of the person concerned who will entrusted with the job to select the suitable candidate for such engagement, and such person and or committee insisted the petitioner to produce the original certificate. That means for their satisfaction, they insisted the candidature on production of the original pass certificate. And they refused to accept the undertaking of the petitioner that such original certificate shall be produced later on as on when the same would be issued by the university. She refused to accept Bolonto. And stop. As and when the same shall be issued from the concerned university. Stop. By making no specific instruction how the selection committee would be satisfied regarding educational qualification of the candidate, the matter was left to the discretion of the selection committee. And how they will exercise, how the selection committee will exercise, and no direction can be given from the judicial institution upon the selection committee, how they will exercise their discretion for their satisfaction as regards the essential academic qualification of a candidate. And no direction can be given to force the selection committee to accept undertaking given by a candidate for production of certificate as and when that shall be available after the process of selection is over. Stop. Moreover, here the entire selection process was undertaken for giving engagement in the post for 1 year. With the passage of time, that 1 year has already been expired. ঠিক আছে? In view, in such taking stock of such chronological event and regime, I do not find any patent error in the order under challenge in the writ petition, and hence no interference is called for in the writ petition. Accordingly, the writ petition is dismissed, however, without any order. Come later on with better case. Okay.
Good.
Next. A group B, 5th August 2007, school.
21.
But in this matter, Mr. Dhruva Ghosh is appearing. He's in some difficulty today and tomorrow. I'm praying for adjournment for next week.
I am for the respondents.
Okay, not this week.
Wait for me.
Twenty-three.
22.
But I pay for the respondent Digha Shankarpur Development Authority.
It's nice to see Mr. Raut in the writ court. Yes. Yes.
I was expecting.
Such comment from the court. Yes. Tell me, you are appearing for the petitioner.
My lord.
But without any brief. No. Yes.
Yes, I think my.
No, no, I am without any brief because I did not know it will appear because I am not favored with a notice of.
All right, my dear lordship, can fix it.
No, Lord, I tell you, Lordship. I'll tell you, Lordship. Lord, first of all, I am not favored with a notice of mentioning. This is an old matter. Dismissed for default several times, restored several times. I have never opposed. I cannot do that. But I was expecting at least Mr. Raut's junior to submit.
It was already appearing in the list of my lord says Sarah.
Maybe it was made out of list.
Wrong time. Well, that's true. That's true. I do admit. But all of a sudden the matter has been included, not that.
Lord, I will be extremely happy if my matters are included all of a sudden.
Already.
No, most probably from the department it has been sent to my court.
Well, a file was sent down from the court of my lord Mrs. Sarah.
Oh.
26.
Okay, tell me when you will be able. It would be
Lordship.
Subject to lordship convenience.
Convenient of all.
Very small matter, my lord. Very small. Very small.
Oh. Come on 29th.
29.
Huh?
No problem.
Yeah. 29.
29.
Yeah, it's a 29.
Okay, my lord. My lord, deeply obliged.
Yes.
29.
29th is a Monday.
30, it would be better 30. Okay, come on, 30.
There is a prolonged weekend during that time.
Yes, yes, yes.
Okay, 30.
That's I'm deeply agree.
Yes.
That's item number 23, Mr. Neeraj Sanjot is appearing on behalf of the petitioner. He was just voting and kindly fix up at 2 p.m. Lordship. He will be coming, Lordship.
Tomorrow?
No, he will not be there, Lordship. If it is be
So not this week.
tomorrow. Yes, Lordship. Kindly fix
Tomorrow?
it tomorrow, Lordship.
Yes. And there is a pattern matter and one fixed matter at 2. Thereafter, it would be both of you are to wait.
As well, Lordship.
It would be better come tomorrow.
Yes, as you, Lordship.
24.
No, item number 25, I'm the petitioner. As per your lordship desire, we have served all the respondents, but the track report is showing they have not received as yet. Kindly, I'm paying for
No, service not completed.
Service not completed.
So not this week or
Not
some
this
more
week,
time
any day
is
next week,
required?
not this week.
Not this week. Okay.
Wait for me.
25.
In 25, my lord, I am for the petitioner. And this is also.
My lord, Mr. Taranjit Theory is applying for the Union of India. My lord, due to personal difficulty, I am praying for not today, my lord.
Not today.
Yes, my lord.
Only.
Only. You will.
My lord,
Also, Mr. Banerjee, you are appearing. Yeah, first page.
for Union of India. My lord, he has filed afresh the writ application.
No.
The old one is not existing. My lord, lordship kindly give me this month.
Well, I took out an application for amendment of the writ petition that was
He has
on
amended
contest,
the-
my lord, that was allowed. Thereafter, I filed the amended petition. This much, I can say.
So this month, lordship kindly accommodate, I am contesting election in precipitation.
This month
This month, your lordship can see this is an old matter, my lord.
of 2011.
Yes, that is true. Any day in the first week of February.
Okay, on the last date of the month.
Last day of
Do it on 31st.
That vote will continue. Bar election is continuing. I am a candidate. That is the problem. Lord, I am moving here and there. Lord, my
may,
management knows it.
may I suggest one thing, my lord? My lord? But it will take, I believe it will take some time because this is an application. Yes. So I will start from the side of the petitioner, my lord. This is a application challenging the disciplinary order whereby I was dismissed from service. After the initial order, my lord, I challenged it before the appellate authority. There is appeal provision. Appellate authority, I lost. Thereafter, I went to the revisionist authority. But there I won. Then matter again came down to the original authority. Then again inquiry de novo held and I lost. Appeal
No.
In any event, again I lost.
So in any event,
Final order of punishment was passed.
Final order was first. I have challenged that order.
But
I have challenged
by
that.
that time you have not filed. By this time you have not filed appeal.
No, well, I have done whatever it is required under the departmental law. Whatever it was required, I had done that. I am instructed to say I have done that. Thereafter, I have come. I lost there.
Yes.
Initially, once I won before the revision authority, then it came back to the original authority. Whatever was there, I have done, and thereafter I filed the state petition. This is the position. So, well, I am not opposing his prayer for adjournment. One thing, my lord, if your lordship kindly takes away on the last day of the month, but I will let me open the case. Then, my lord, my learned friend will have.
When the election of the bar.
29 to 2nd February. That is the problem.
And today is the 9th or 10th. 29, there are 19 days in between.
So do it before any day. Is making.
Let my learned friend take information at least that from 11 to 23, whether his client is still strong or not to fight this case.
To give a tough fight to you.
Or my lord, let it be made part-hard, my lord. So that
I have not
kindly hear me. Before that, at least 5 times, I am instructed to say by my learned advocate on record, at least 5 times the matter appeared in various courts, and it could not be heard. This is our misfortune. So this is perhaps, this is the sixth time the matter has appeared before this court. So my lord, if your lordship takes up.
My lord, the only predicament.
Actually, seniors taught the junior don't say lie. Here I have not heard substantially the matter.
But I can,
yet you
no,
are sitting on
I
paper, you are
can,
saying that
but I can open
you
here,
record this of the
but I can open here and now. I can open the case. I can open the case here and now.
Oh, if Mr. Vajpayee is agree, I have no inconvenience, nothing, no objection to here.
My lord, he will not agree because he knows that I am contesting. And he is the.
As your lordship pleases, but I will not say anything more.
So do it on 5th. Let it appear in the monthly list of February. Then you mention this matter, then the matter.
But kindly fix up.
uploaded.
But instead of monthly, kindly fix up a date. Any date, your lordship, kindly fix up a date.
So come on the last date, okay?
Or 5th was all right.
No, keep the monthly date. Monthly figure.
Is the date on which monthly list you will
At the top.
No, yeah. My lord,
At the top.
in the monthly list, it would not be done.
yes.
Because in the monthly list, according to year, the list will be prepared automatically.
Then 7th.
So 6th.
Six.
Yeah.
Very,
6th
very.
matter is fixed. That is the problem.
I will start. Your junior will be here.
7th.
I will open.
One day heaven will not fall. So
7th, okay, 7th.
What I'm good.
একটা order করে দিন heard the learned advocate appearing for the respective parties list the matter for further consideration on 7th February 2024.
If possible, at the top of the list. If possible.
আচ্ছা, fairly at the top of
Fairly at the top. Yes, my lord, I'm grateful.
Yeah.
26.
Your Lordship, in this matter, Senior Advocate Bhudev Chatterjee, Your Lordship won't be able to come to court because his son broke his leg, Your Lordship. That's why I'm praying for not this week.
But in the next week, he will be able to do it.
Yes, Your Lordship, he'll come.
Okay, not this week.
Grateful, Your Lordship.
27.
I am the writ petitioner in this matter. The subject matter of the controversy is order of the ombudsman.
Whether it would be possible before recess or
no.
It will so enjoy the recess, come after recess. Any inconvenience?
Let it be at 2 p.m. my lord. আমি তোকে এত ক্ষুদ্র বলে দিই বলি খুব
Tell me what you want.
Any if it comments to your lordship any other day because at 2 p.m. actually court number 13.
Tomorrow would be any difficulty? Tomorrow?
Let's try, yes.
Okay, not today. Not today. Not today. Enjoy the recess and then come.
By mistake, I could not serve the notice in due time. For which kindly adjourn the matter.
I am for the state one.
State, except state, who are
Only
the
the state
respondents?
petitioners.
Oh,
Only state is
respondent
the party.
present.
State is only the party. Only answering party is state.
Oh, answering respondent state.
In due time, could not serve the notice. For which adjourn the matter fortnight.
Fortnight.
Yes, man. In the meantime, I will serve the notice.
It is not clear. Whom you will serve? State is
state কে দেবেন তো কপি আমি তো স্টেটে অ্যাপিয়ার করছি প্রাইভেট রেসপন্ডেন্ট তো নেই এই মামলা কোন মামলা এটা কি নাম
Anwar Sheikh.
2012.
Anwar Sheikh.
In Anwar Sheikh there is no private respondent, my lord.
So kindly
There is no private respondent.
There are 8 respondents, 8 are state respondents.
State, huh? So not this week. Come in the next week. Okay? Get prepared and come.
29.
Not appealing for the petitioner. Mr. Ekram already led by kindly not today.
Not today only.
Today call Oh, not
Okay, not today.
30.
30 my lord.
I am the petitioner. Kindly appear to not this week.
Not this week.
Yes, my lord.
Okay, not this week.
Grateful, my lord.
I'm for the petitioner.
Yeah.
I'm for the railway.
But kindly look into your lordship's last order. On 14th December 2023.
Is any officialist present?
My lord, I have communicated the order. They have received. My lord, they have not.
Actually, should be difficult for them to remain present also.
This is a personal appearance. Direction for personal appearance.
Oh,
From the state government.
none is defending the state. On earlier occasion, who appeared on behalf of the state?
Initially, Mr. Mahanti, Anuruddha Mahanti was appearing. Thereafter, these honorable court pleased to appoint Mr. Chondi Charan De to represent the state.
This court engaged?
The coordinate bench.
This panel was changed. That is why Mr. J is here. They notice you.
A personal appearance.
Not personal appearance in that circumstances.
That's why you also last occasion directed the land acquisition collector to depute an officer along with our records.
Mr. Samanta, you appear? You give your just court is interested to look into the joint survey report. Question is whether the portion of the land was acquired, of the petitioner land was acquired or not. That is the question.
Sir, ultimately in the year 1958 to 59, the land was initially acquired. Documents as far available, documents in the office. But through us, on the request of the RB, the execution process will be withdrawn, and that notification has already been was issued in the Gazette. This is the scenario, actually. Actually, they wanted the land, but the request was
that was the stand of the state government in their affidavit. In their affidavit, state government specifically says initially land was acquired, but subsequently by notification, acquisition was cancelled. The acquisition was done. Number, you will also kindly see but order dated 8 December 2022, a coordinate bench of this court, 8 December 2022, directed a joint survey to be conducted by the land acquisition.
So your stand of your department is that you have not acquired any land on the basis of the requisition made by railway authority.
It was initially acquired, thereafter.
Sir, actually, as it is a long old case, 1958 to 59, most of the papers are found and released. There are some maps which are torn, right, which have cannot conducted. But in the meantime, afterwards, whether the land was acquired or not, the office is not in.
No, in this way, state will not
জয়েন্ট
be
সার্ভে
able
করার
to
কথা, এলিয়েট করার কথা রেলওয়ে পিটিশনারকে নিয়ে।
take his liability.
Railway and petitioner. Railway and the petitioner.
State.
So, do one thing. You have a consultation with Mr. Samanto. Whatever document you have got, you get it copy and hand over to Mr. Samanto. Actually, be it clear that petitioner has come before this court with a plea that a portion of his land has been utilized by the railway. Okay. Now court want to know whether on the basis of the requisition placed before you by the railway authority, you acquired any land or not. That is only the question. Okay. So far, your part is concerned. If you say, no, I have not acquired any land, I have not received any requisition from the railway authority, then I shall ask railway authority.
Subject to correction, my lord, the state has used an affidavit in opposition in the writ petition. In their opposition, they categorically says that we have not acquired.
No.
Whether the opposition was filed before the holding the joint survey as
Joint survey is not, they have not come with the report of the joint survey.
You see, Mr. Samanto,
As per the opposition, my lord, the entire land is a freehold land.
on 10th April 2023, a coordinate bench of this court, Justice Joyce Gupta directed both the railway authority and state to hold a joint survey. He is saying that while a railway has
or not acquired,
utilized, already utilized.
Land utilized.
Already utilized a portion of the land.
That to be determined.
If it is possible that it be returned, if it not
That is the
possible,
reason, my lord,
it is to be
yes.
compensated.
It is required to look into how much land has been lost.
May I suggest one thing, Lord? Kindly reiterate that order. Pass the say direction for holding joint inspection once again, Lord, in presence of the petitioner also.
No, joint inspection was held.
No, perhaps not.
I was not a part of the joint.
Yes. It was not the part of the joint inspection. That was not a joint inspection.
You are special land acquisition officer. Land acquisition officer. DM is land acquisition collector. You are land acquisition officer.
LAO.
So no joint survey was held in terms of the order dated over 10th April.
We were not present there.
Then it is not a joint survey.
It is not a survey.
On the part of the railway, the inquiry will be conducted.
A survey was conducted by the railway, my lord.
Okay.
But I also do not have any knowledge that the joint survey was conducted. Because the railway has said that the joint survey was conducted, but I have no instruction on that. না সেটাই order ছিল, that was the order. ঠিক আছে।
শেষ হবে না।
না, it's required to know how much land has been utilized.
If it is required, how much
has been taken for construction or for not.
অর্ডারটা আছে কাছে?
তোমার 10,000 তোমার এপিডিএমটাও দিয়ে দাও।
না 10,000 অর্ডারটা আছে।
না গো।
তোলা নেই না?
না আমার তো নোট করা আছে ব্রিফে।
What are you saying? On 23rd November 2022, Deputy Chief Engineer Con 1, Construction 1, Eastern Railway Howrah, by giving a letter, inform you, requested you that a Amin may please be deported for demarcation of the land in dispute.
But he was not, he saying he is not there. They were not there.
23rd November 2022.
That's how state ছিল। May I humbly beseech, my lord, kindly direct three of the parties.
Yes,
state,
my lord.
Union of
Kindly,
India and
kindly
the
read.
petitioner
Huh.
to be present in a, all of them may be present in the joint survey, my lord.
And in the presence of a responsible officer of the state government.
Both the state and central.
সেন্ট্রাল কে দরকার না, ও তো তোমার টাকা দেবে।
In this petition, the petitioner claimed that a portion of his land has been utilized by the railway authority. Now, to decide the issue, and hence he paid for compensation in respect of the land so utilized, or in alternative, he pays for release of that land. ঠিক আছে, আচ্ছা, stop. To decide the issue involved with the writ petition,
31.
the court wanted to ascertain as to whether any land or any portion of the petitioner land was acquired by the land acquisition collector on the basis of the requisition made by the railway authority or not. Stop. A coordinate bench of this court, by passing an order dated 10th April 2023, directed both the railway authority concerned and the LA collector Birbhum to hold a joint survey. Stop. The learned advocate representing the railway authority submits that he is not in a position to inform the court as to whether any joint survey was held in terms of the order of this court passed on 10th April 2023. Hence,
Well, that was not my instruction. But I do not have any instruction. The whole
June.
No, my lord, I do not have any instruction to that effect. Because my client was never informed. Well, you have been informed by the railways, not the state government.
the last line. Now, there is a confusion as to whether in terms of the order dated 10th April 2023, any joint survey was held or not. Stop. Hence, to eradicate such confusion, this court, by passing an order dated 14/12/2023, asked the LA collector Birbhum to depute one official who is acquainted with the facts and circumstances of this case to remain present in the court at the time of hearing of this writ petition with all the relevant records. Stop. The land acquisition of pursuant thereto, the land acquisition officer Birbhum is present, but he is not in a position to state clearly as to whether the joint survey was held in terms of the order dated 10th April 2023 or not. Stop. None appears to represent the state, although this court, by passing this order, indicated that presence of the state representation is very much required to give judicial answer to the query raised in the writ petition. Stop. I find Mr. Samanto is present in court, who usually appears on behalf of the state. Stop. I request Mr. Samanto to appear in this matter and to avail necessary instruction. Stop. You.
I will take instruction.
What court wants to know?
Yes, yes.
If state do not acquire any land of the petitioner, then I shall impose the liability you pay.
Yes, yes.
You have utilized, so you shall not be able to return, release the land, so you pay compensation. Now, whether he will again ask him the takes help of the state or not, that is his headache, his lookout. Okay. Now, whether state acquired the petitioner's land or not,
this is the sole question.
It is the sole question. So far, state government is concerned. Then I shall see the railway authority. Without acquiring, how you can utilize the
kindly direct further direction.
Another question is involved, whether actually any part of the land the petitioner has been taken for construction.
That is the reason the your lordship has directed for joint.
In that circumstances, state is with us. I shall ask Mr. Client of Mr. Samanto to depute one a surveyor or Amin who will survey of the land. They will ascertain and give report whether such and such portion of the land of the utilized.
The actual topography of the land, my lord.
You are before the court of law.
Kindly pass that direction also, my lord.
But kindly direct the joint inspection also.
Kindly
because in their affidavit, state has taken their stand. States have categorically taken their stand. You also kindly look into the affidavit.
And if it is found that no joint inspection survey was held in terms of the order dated Ato, the railway authority and the land acquisition collector, Birbhum, are directed to hold joint survey within 15 days, within 15 days.
4 weeks.
Within 3 weeks from date. And the joint survey report and the joint survey report shall be submitted before this court within 4 weeks from date. Positively within 4 weeks from date. Okay? So leave this matter for further consideration. 4 weeks.
Two things will not at the time of inspection.
Date, 10th February. Today is 10th January, 10th February.
Leave this matter for further consideration on 10th February.
But two things will at the time of here holding joint inspection, my lord.
12.
Presence of the writ petitioner is required, my lord. Otherwise, my lord, it will not be possible. Yes. Everything to be required. With the
and at the time of holding such joint survey, both the railway authority and the railway collector Birbhum shall ensure the presence of the petitioner.
With documents. With documents. With documents.
So the donorship and documents are not required to be shown first.
No, my lord. If it is not his land, my lord.
Petitioner shall remain present, all its documents.
With the copy of the writ petition and all records. Because all in my writ petition.
Show your documents.
Have
you given?
Yes.
Yes.
Yes. The original, the deed, I have annexed in my writ petition.
That will suffice. If that is
petitioner on receipt of notice either from the LA collector Birbhum or from the any official of the railway authority shall remain present with all the
documents.
documents relating to his land, relating to the
Land in
to his
question.
land at the time of survey.
Yes.
Such joints. Oh, 10th, 12.
My lord has directed for regularization of my appointment, my lord.
Hey, you do regular school.
ব্যাস তাহলে গেল এত কষ্ট মাত্র
32, Your Lordship, I am here on behalf of the petition. On the previous occasion, Your Lordship directed us to service the matter.
I am from the bank. My lord, we want to file the APDB in opposition in respect of the can which have filed previous on the last occasion.
Can also.
Because as per my instruction, my learned senior is on
1, 2, 3, 4, 5, 6. They have filed 6 can.
Yes, my lord. 6 can, Your Lordship.
6 application. And we will file opposition in respect of all the can.
As per my instruction, my lord, we want to file the can, my lord. We want to file the APDB in opposition.
Affidavit
You are appealing for the petitioner.
for the petitioner, Your Lordship.
So one by one tell about what about the application. Can 2?
Can 2, Your Lordship, it's for the restoration.
Is still pending. The matter has not been restored.
Still pending.
Oh, the application. Oh, the application for restoration was also dismissed for default.
Lordship.
Now, the can 2 is original application for restoration. Kindly allow me to understand. Okay, can 2 original application for restoration. Okay. What about can 3?
Can 3, Your Lordship, is the substitution. Substitution.
Substitution. Who died?
Your Lordship, the petitioner died. Chintamani Pal. And Chintamani Pal's son is Kalyan Pal is representing.
Can 3 substitution. What's the matter about?
Your Lordship, Chintamani Pal used to work in IndusInd Bank. Later, it got merged with Allahabad Bank. There, he was a cashier. The post of a cashier. But he used to, the branch manager used to send him outside to collect cash also on the date. And on
in the writ petition, the final order of punishment and passed by the disciplinary authority and appellate authority was challenged.
Your Lordship,
okay, you will get money if the order are set aside.
Lordship.
Now, can 3 substitution? Had it been allowed or not?
Lordship.
You are substituted.
Your Lordship, his son has been substituted, Kalyan Pal.
Chintamani Pal. Who is Chintamani Pal? Son or father?
Father. Chintamani Pal was the employee of IndusInd Bank, later Allahabad Bank.
আচ্ছা আমি এটা ইয়ে করে নি আপনাকে দিচ্ছি টোটাল ক্যান 3 যদি ডিসপোজ অফ হবে তাহলে এখানে লিখে আছে
হ্যালো
is filed on behalf of the respondent later if private and requisition.
My lord, Mr. Rai is leading me, my lord. He's on leg in court 6. As per his instruction, my lord, Mr. Om Naran Rai. On the last occasion, he appeared.
Okay, I shall not kill you like Obimundo. Don't think. Kindly allow. Can 3 is the
substitution.
Then can 4?
Can 4, Your Lordship, is the condolation of delay.
Condolation delay in filing?
Condolation of delay in filing of the substitution.
In filing of the substitution application. Achha. Can 5,
Recalling the
huh?
recalling the order.
Can 5,
Can find a recalling of the order dated
recalling of the order whereby can 2 was dismissed. Huh?
Can 5 for recalling of the order dated 9/9/2022 of the restoration.
Don't force me to find out the 9/9. Tell me.
Of the restoration.
of the application
Application.
of the dismissal
Dismissal
of
of can
call the order of dismissal of can 2.
Can 2.
আচ্ছা, এটা restoration of can 2. আচ্ছা, now can 6
for condemnation of delay in filing the restoration application.
what? Can 6 condonation of delay. Okay. Now can 7
Can 7 is
Can 7
is the sixth number restoration of the condolation of delay.
Can 7, there is can 7 also.
Oh, can 7.
Yes, can 7.
Six number is can 7.
Can 7 section 5.
Section.
In delay in
Number
filing
6.
the restoration application by recalling the order dated after. So if can 7 is for condonation of delay, what about can 6?
Lordship, can 6 is for recalling of the order.
Recalling of the order, which?
Of the restoration of can 2 restoration application.
তার জন্য তো can 5.
Lordship, can 5 number of can 5 is can 6 number E.
Better you verify, you take the record, you verify when your senior will be available.
Next week. Next week.
Okay, not this week. You file. You even given liberty to check my file also. Okay. Can 1 for can 2 for search purpose. Can 3 for search purpose. Okay. You write down. Not this week.
Affidavit of service number
13. And by inform Mr. Samanto, yes. Okay.
Preferring unlikely.
Okay, neat. 33.
33.
My lord, on behalf of Mr. Ekamul Bari, my lord, I'm praying for not this week.
Okay, not this week.
34.
I'm for the petition. I am praying for not today.
Mr. Banerjee.
On behalf of the petitioner. Yes, sir. Come to the court.
Okay, not today. Come tomorrow.
35.
Lord, I'm applying for the petition.
There are 2 applications, can 1 and can 2.
Lord, can 1 is in connection with the main writ petition. Can 1, can 2, yes. Oh, এটা না এটা কার ফাইল?
Oh, that matter.
আমি বলি
That matter, re-investigation.
Yes.
It was investigated that matter.
Yes, yes.
What is your
Yes. Now, my lord, allow me to place, bear me for few minutes, my lord, I shall place. Now, my lord, what happened, my lord, initially, my lord, the complaint of the petitioner was investigated by the local police station. My lord, the investigation was absolutely, my lord, not in tune, my lord, as it should be. My lord, the petitioner approached this Honorable High Court. This Honorable High Court in the year 2009 by order dated 27th of August 2009
directed the Central Bureau of Investigation to take up the investigation in respect of the murder of the deceased brother of the petitioner. Now, my lord, pursuant to the said order, my lord, the CBI, my lord, completed its inquiry and filed a charge sheet in the court below by a charge sheet dated 31st of December 2010. Now, my lord, after filing of the charge sheet, we informed, my lord, the CBI through letters and to several other authorities that the missing links which has not been investigated by the CBI authorities during investigation. My lord, interestingly, my lord, the CBI, the person who has filed the charge sheet, Mr. Arun Bothra, my lord, the DG, the DIG of CBI, my lord, he himself writes a letter, yes, my lord, the investigation which was carried out by the CBI authorities is not an open investigation at all. It's not investigation as required by the CBI authorities to be done. Now, my lord, taking all these documents and they, my lord, they file a supplementary charge sheet thereafter. After we write a letter, these things are to be looked into. What they do is, my lord, they add one extra accused in the supplementary charge sheet. My lord, who is this one extra accused? Mr. Pranay Kumar Singh. My lord, why he was added? Because the gold ornaments which my brother was wearing, my lord, in his body, my lord, that was purchased by my lord Pranay Kumar Singh. And he has a jewelry shop owned in his name in that locality itself. Now, my lord, after this supplementary charge sheet, only by implicating Mr. Singh into the case, my lord, they said that we have completed. Now, without considering our letters where we indicate other things which needs to be looked into, my lord, we were constrained to file a writ petition before this court saying that, look, the CBI, whatever has done nothing. It has only, my lord, what the police has done, has reiterated its thing, but it has not gone an investigation on its own, for which it was appointed. Citing, my lord, grounds in the writ petition and the letters which were addressed to the authorities indicating what is being there. Now, my lord, at that juncture, Justice, my lord, this honorable court passed an order, was satisfied with the submission and said, now I am going to monitor it. My lord, the last order of this court by pursuant to which this is made returnable. My lord, how this is being monitored, the court said you file a further report before this court, whether you have looked into these things or not. That report probably, my lord, has been filed by Mr. Trivedi, my lord, before your lordship. Now, my lord, court is monitoring. My lord, it's not a case, my lord, where they say that we have completed the investigation and there is nothing to be done.
No. Where that order?
Yes.
The court will monitor the investigation.
Yes. Kindly takes up the last order dated. Kindly 8 December 2016. এই রিট পিটিশনে যে অর্ডারটা পাস হয়েছে 8th of December 2016. Now, my lord, may I place the order for my lord's consideration? My lord's got the order, my lord?
No, I direct CBI to reinvestigate the matter and the investigation shall be monitored closely by the Joint Director CBI.
Yes. Now, my lord, court calls for a report. My lord, this reporting, my lord, is whether the investigation has been carried on the points or the links which have been supplied by the petitioner. So, my lord, court is through the DGI, my lord, is monitoring by the report whether this has been done or not. My lord, court has to appoint somebody to monitor. Court has, my lord, will monitor subject to what report comes in.
Now, whether report was called for by that order?
Yes. My lord, kindly sees the internal page 9 of the order.
Yes.
Therefore, considering the gravity, the previous, my lord, says, my lord, where the missing links are there. The court has gone into that observation. Therefore, considering the gravity of the case and considering the submissions of the learned advocate for the parties, as well as the way the investigation was conducted by CBI, I direct the CBI to reinvestigate the matter.
Yes. The CBI shall file a copy of its comprehensive report before this court in the writ petition for passing necessary direction is required.
Yes. So, therefore, now court is monitoring by this.
Submitted their report.
Yes. Now, a copy has not been supplied to us, but to my lord. I don't know, my lord, what report has gone before, my lord. Whether the missing links which have been supplied by me, my lord, has been looked into or not, my lord, I don't know.
Where is that letter?
Yes.
Have you
Well, there is a
got that letter on record?
Yes, my lord, that is there.
That means the letter by which you detected some missing links.
Yes, yes, yes. Well, kindly takes up page 143 of the writ petition.
One.
And my lord, this court takes note of this, my lord, of the letter in the order itself, my lord, which is at internal page 3. My lord, I tell your lordship, my lord, in short, my lord, without troubling my lord, with the entire. What is happening, my lord, from the charge sheet? My lord, what happened, my lord, 2-3 days.
Actually, hurriedly, I am trying to find out that on earlier date, most probably you stated that one accused person has been left out.
Yes, my lord, that's why I say, my lord, 2-3 dates I will mention. My lord, the death of the brother occurred on 6th of July 2007.
Yes.
My lord, to investigate this, my lord, what was there before the CBI, my lord, on the day when he took up the investigation was, my lord, at 9:50 p.m. on 6th night itself, my lord, 2 persons, namely, my lord, Bikas Bishojit Orofe Montu, and my lord, another person, namely, my lord, Bikas Singh, my lord, was present in an STD booth. And my lord, a call was made from the personal mobile of the Mr. Dharmesh Shai of the STD booth owner. And at the same time, my lord, thereafter, my lord, my lord, the victim, my lord, on receiving the call, left his house with a bicycle and an umbrella as it was a rainy day. And thereafter, my lord, on the next call in the mobile of the victim was from the brother of the victim, that where are you? But nobody picked up. He hurriedly was in tension, and thereafter a person informed the police that I have been informed of a dead body lying in a garden which has received 18 wounds, stab wounds, and a V-neck throat slit cut. So, my lord, from this only, my lord, I say, my lord, if 2 mobiles number have been used to call up the victim to reach to the spot, my lord, then the time as mentioned in the charge sheet is 9:50. At 9:50, there cannot be 2 calls received. 2 call has to be either at 9:50 or it has to be 10 minutes after or 5 minutes before. There, the CBI doesn't go into that investigation and reiterates with the police that at 9:50, 2 call has gone. This cannot be done. This is not imaginably possible. And police stresses call record of from one mobile number, and that is up to 10 p.m. at night. My lord, call went at 9:50. Police stresses the call records or tower location up to 10 p.m. at night. The distance from the victim's place to the spot is 2 kilometers away. As per the FIR or the information supplied by the victim's family, the brother left the house at 10 or within 10:15 with cycle and umbrella. So if he has to reach 2 kilometers with a cycle, at least 15 to 20 minutes would take time. So why the tower location was identified before the murder has happened, not after or before or at that time? This is first. Second is, my lord, if the brother, my lord, the place where they say, my lord, the body was found, they have found the body. They do not identify the murder spot. They say the body was found from a garden. My lord, that garden is a bounded boundary wall garden, my lord, of the corporation with high boundary walls, with police guards, because that's a picnic spot. And my lord, just adjacent to that picnic spot is, my lord, police quarters with markets which runs till 11 p.m. and 12 p.m. at night. So, my lord, in any event, nobody could enter the garden after the evening because its doors are locked. So, if one has to enter the garden, there is no investigation on that count whether the murder has happened somewhere else and the body was then left dumped in the garden. So there was no investigation on that count. Thirdly, my lord, suddenly after naming Vikas Singh and Vishwajit Gupta, suddenly in the charge sheet they name one person, Shibu Singh.
One person?
Shibu Singh.
Yes.
Suddenly, my lord, all of a sudden.
Police.
CBI.
CBI. Oh.
And police as well. Both. Ek minute, sir. Suddenly they name Shibu Singh. My lord, I put this question to myself when an investigation is happening. When two persons have called and you name a third person and you say he is one of the accomplices to the murder, will you not state in the investigation where this person was present at the time of murder, whether he was there with when the call was made, or he was made to stand somewhere where the victim would reach there? Suddenly Shibu Singh is a part of this murder. How did Shibu Singh enter into this murder? Who called Shibu Singh to be present at the murder spot? Because he was not there at the STD booth. That's the investigation. So how did Shibu Singh join this Vikas Singh and Vishwajit Gupta? Then they say it's a planned murder. So if it's planned, who has planned it? Thirdly, my lord, most interestingly, my lord, suppose, my lord, I receive a certain call from an unknown number. My lord, it's not possible to imagine somebody receiving a call from unknown number would suddenly leave his house with a cycle and an umbrella at 10 p.m. at the night when he returns back to home with work. And my lord will meet an unknown person who has a motive to loot him. My lord, either the victim knows these two persons, and on receive of this call, he immediately left the house, or he was told something in the phone call which compelled him to leave. My lord, there is no reflection on that count in the investigation. Why was victim compelled to leave the house? And when the police says, or the CBI also reiterates, that it's a murder with a motive of loot, or, my lord, robbery, if I say even. My lord, nobody would leave a house on a call of a dacoit to put himself into the murder spot. My lord, there has to be an investigation to that angle, which would suggest why he was compelled to leave the house. My lord, there is no finding on that.
Now CBI charge sheeted who?
This
one Shibu Singh was initially charge sheeted.
3 persons were initially charge sheeted: Vikas, Vishwajit, Shibu. And added was Pranay. In a supplementary charge sheet. And till date, this missing link of Dharmesh Shai, whose mobile number was used, personal mobile number was used to call him.
Now your grievances is that Dharmesh Singh has been left out.
Left out first. The CBI puts a supplementary charge sheet against Pranay Singh, but at the same time, my lord, he leaves. My lord, the owner of the jewelry shop, he leaves out.
Owner of the jewelry
He
shop.
is the son of the owner.
Name
is Pradeep Kumar Singh. Na Uttam na. Pradeep Kumar Singh. Na, Shudhu Pradeep Kumar. There are many people involved. Pradeep Kumar Shao. Sorry. Pradeep Kumar Shao. Pranay Kumar Shao, na? Pranay Kumar Shao Singh, na.
Pranay Kumar Shao has been charge sheeted.
The original
Pranay Kumar Shao is as owner of jewelry.
He is the son of the owner.
Son of the owner.
Son of the owner.
What role he has played?
My lord, son. Now, my lord, yes. Interestingly. My lord, my brother was also involved.
They are involved in the murder, or they just purchased the stolen article?
No, this part was never investigated. I gave them that link. My lord, my brother was also involved into this gold ornament.
No, charge sheet has been submitted under Pranay Kumar, under which provision?
My lord, only keeping
379,
stolen articles and, my lord, destroying the evidence.
379, 411.
Yes, and destroying, my lord, material evidence. He was booked under that.
Yes, not under section 302.
No, he was not looked into at all.
Purchased stolen article.
Yes.
Yes, 379, 411.
Yes. Now, my lord, if that be so, My lord, the mobile phone of my brother was also sold off to at least 5 people that is indicated in the charge sheet. Immediately after murder on the next day. Those persons were not even called on. Who sold you the mobile phone? Where from this mobile phone was received?
If my learned friend will take another 15 minutes, may I come from courtroom number 28 minute? No matter is being called.
হ্যাঁ তুমি 15 মিনিট লাগবে
15 মিনিট লাগলে আমি 10 মিনিট বলতে চাই। দাদা, no, my lord, what I'm saying is,
My lord, I would only indicate why
filed a
my lord court.
Would you be able to show me the last charge sheet submitted by the CBI? Page.
That is at page. My lord, it starts.
Supplementary affidavit.
Starts. Kindly turns to page 53.
Yes, Mr. Tripedi.
I'll be back.
The charge sheet submitted by CBI is at page 53. Starts from page 53.
53 of writ petition.
Of the writ petition.
Okay, last page. You take me to last page.
My lord, my lord, kindly last page of the charge sheet.
Page 66.
Yes, that is page 66. My lord, kindly says prima facie, Vikas Singh, Shibu Singh, and Bishwajit Gupta. That is there with the police. And on this investigation, my lord, court directed CBI. On the same report, my lord, they obtain the report from the police and they say, I have investigated. And they file a charge sheet. My lord, first of all, my lord, I would show, my lord, from the charge sheet itself.
Avenue is always open for any investigating authority for further investigation.
No, my lord.
And filing supplementary charge.
No, my lord.
Generally in such case, where there is possibility of recovery of further materials or involvement of any person, further person in the offense, then they reserve their right generally in the charge sheet to file supplementary charge sheet. And it may be done that the EA will go on, continue to conduct further investigation. And if any further material is collected, they will file supplementary charge.
To answer my lord's query, my lord, today, my lord, prima facie court was satisfied whatever charge sheet filed by the CBI.
No, I have not read it.
No, my lord, this court, I will say not my lord, this court was prima facie satisfied that the charge sheet which is there before the court by the CBI is they have not even conducted a single inquiry what has been left by the police authorities. And
in the FIR, there was an unknown against unknown person.
Yes, obviously, because body was recovered on that basis, FIR was lost.
FIR was lost.
And thereafter, on our query from the family members, we have said that at 9:50, my lord, call was received. He left out of the house at 10:15 with a bicycle and an umbrella. And even till date, my lord, those cycle and umbrella was not recovered. Even we know, my lord, suppose, my lord, I go by a cycle, I may place the cycle, my lord, 1 kilometer away, I may be dragged to a spot. Then from, my lord, that 1 kilometer is an important spot where my cycle is. My lord, they say they only indicate that the body was there in the garden. That's a murder plot. That cannot be. There has to, because
the charge sheet has been submitted before the court below.
No, but yes, definitely.
Case has been committed to the court of trial.
Yes, but no, it was trial. It was stayed by this court after looking at the charge sheet. The trial was stayed because this charge sheet, if is there in trial, even this 3 person I can show, my lord, will get acquitted. By this charge sheet.
Generally, after completion of investigation, the police authority or IO submit the charge sheet before the court.
Magistrate.
Learned CGM.
Magistrate.
Then CGM will take cognizance of the offences. Thereafter, he will come to a conclusion that it is a trial by the Court of Sessions. Then he will commit to the Court of Session. Then the Session Court may either tie the case himself or made over to another additional district session judge. Now, whether the charge sheet has been submitted before the charge sheet by the CBI, before the magistrate, or it was already committed
before the magistrate.
So there was no commitment.
No.
The case has not yet been committed.
No, not yet been committed.
Whether charge sheet submitted by the CBI has been accepted by the CGM.
Because this honorable court has stayed. The entire proceeding has been stayed. So there is no further movement, my lord, after passing of this order. Now, my lord, here, my lord, even to answer what is falling from.
Now another query, whether by passing the order a coordinate bench directed the CBI to take cognizance or to take notice of your grievances.
Yes.
Or the points you indicated.
Yes, absolutely. My lord, that's the entire gamut of the order. If my lord reads that order of 8 December, my lord will find the entire gamut is, my lord, those very important missing links. Even the post-mortem report, my lord, doesn't indicate the time of death. And CBI also deliberately overlooked it. Where, my lord, they say the viscera is preserved, even till date. I don't know, my lord, how they will find out the time of, but it's a case of a doctor. The CBI has all the materials before it.
Viscera is required where death would be due to poison.
My lord, they say.
Okay, basically
Poison. Stab injury.
PM report will sufficient.
Yes.
Stab injury. Now,
postmortem report. Post-mortem report doesn't indicate the time of death.
Weapon which is by which the stab injury can be caused had been used.
My lord, the post-mortem report doesn't indicate the time of death. They implicate these 3 persons, my lord, as the murderers. My lord, the murderers, if they are finding the murderers, they would say when they have killed it, they have killed the person. So at least from that, the time of death should be reflected in the investigation. If the murderers say we have killed him at 11 p.m., so it should be found in the investigation or in the supplementary charge sheet. Nothing is there.
It may come also from investigation. When
they say we have
notice, then moving back towards.
Yes. Well, the method to find out.
Yes. Although it is not accurate method, but generally it is followed. The Raigor notice, then it was winter season or it was summer season.
Rainy season.
Then what time may require to develop Raigor notice on the dead body. Then that time would be calculated moving back.
Yes.
From the
just like my lord, carbon dating, like age of to find out ages. So these things, my lord, are completely lacking, my lord. He says first paragraph, the person Uttam Pal who has informed the police about the dead body, his statement is, I have been informed by somebody. But that name is not even there.
You take me to that portion of order where the issue pointed out by you has been.
Yes.
CBI was directed to the.
Yes. My lord, kindly takes up internal page 2
of the order.
Yes. My lord, this is the submission of the learned advocate I am indicating. Vishwarup Bhattacharya, my lord, has found that.
Yes.
My lord, I am not reading the entire. Mr. Bhattacharya refers to a letter dated long back 20.
Court says that CBI
court
that
takes
you look into this.
Yes, my lord, right, coming to that, my lord. In that page, court takes notes of page 74 of the writ petition. Kindly turns over the next page, my lord. Court take note of page 145 of the writ petition, the letter which I have shown. This was indicated by the learned advocate, then he relied upon decision. Then learned advocate replied for the CBI, replied at internal page 5. Now considering the submissions advanced, my lord has got that. In considering the submissions advanced by the learned advocate for the respective parties and after meticulously scrutinizing the case diary as well as the record, the documents annexed to the writ petitions, this court is not at all convinced by the submission of Mr. Ali that no further investigation is at all required in the present case. On the other hand, from the face of the documents,
I couldn't find it.
Internal page 5, third paragraph.
Internal page 5, yes.
Third paragraph.
Yes.
Considering the submissions advanced by the learned advocate for the respective parties and after meticulously scrutinizing the case diary as well as the records and the documents annexed to the writ petition, the court is not at all convinced by the submission of Mr. Ali that no further investigation is at all required in this present case. On the other hand, from the face of the documents, it is apparent that though the CBI was entrusted to investigate the matter by the earlier order of this honorable court, but it is found that the investigation has not at all been conducted by the CBI in an healthy manner, or in other words, the way the investigation was conducted is not at all up to the mark. That being the scenario, court relies upon a decision. Miller, I'm not troubling. Yes.
Pujapal.
Then, Milord, internal page 9. In my considered view, it is a fit case where the court should direct re-investigation. In the Pujakal, Milord, I'm not troubling. Therefore, considering the gravity of the case and considering the submissions of the learned advocate for the parties as well as the way the investigation was conducted by CBI, I direct CBI to re-investigate the matter, and that investigation shall be monitored closely by the Joint Director CBI. The CBI shall file a copy of its comprehensive report before this court in this writ petition for passing further necessary directions if required. So, my lord, court is monitoring the investigation now. My lord, when court is monitoring the investigation, my lord, in my respectful humble submission, Honorable Supreme Court has in number of cases has reiterated, when high courts are monitoring cases, it cannot receive a report and just relegate it to the courts below. Rather, it's the duty cast upon the court to see that the reinvestigation which is monitored is being directed in the proper manners as desired from the information supplied. And, my lord, most respectfully submitting, my lord, when we seek an CBI inquiry, my lord, apart from state agency, my lord, it's only the High Court vested with 256 or Supreme Court vested with Article 32, my lord, is empowered to direct CBI because of the constraint made under the Police Act and, my lord, entries in, my lord, list 1 and the list 2 of Schedule 7.
That question is over.
That question is over. Already direction. So, therefore,
now at this stage, whether writ court will hold that the investigation conducted by the investigation conducted by the CBI is not proper, and hence further direction for investigation.
My lord, I say, my lord, court is monitoring. My lord, when court says, I am monitoring, I want a report. My lord, court is monitoring. I am on this. Court is not left the writ petition disposed of by saying you are directed to reinvestigate. Writ petition disposed of. No. Court is monitoring the reinvestigation. My lord, I am on this. When court is monitoring, my lord, it's duty cast upon by humbly submitting, my lord, it's duty cast upon the court to see that reinvestigation as directed is done, answering the questions which are prima facie apparent from this charge sheet.
That means you are inviting the court to enter into the details of the investigation.
I have to. Because if I leave there.
Monitoring and supervising, there is two different words. And the nature of work also.
My lord, the court has used monitoring. My lord, this court has used the word monitoring. My lord, it can be interjectly used, my lord, supervising on monitoring. My lord, I say, when I supervise, my lord, I have to be satisfied the work which I supervise is done correctly or not. In the same breath, my lord, when I am monitoring, my lord, I have to ensure that everything is clean and done, my lord, in the manner it should be. It's all the way same. I may be using, my lord, different stances or sentences, but it's same. So therefore, my lord, to even to assist carefully, my lord, without troubling my taking my lord's trouble, I should have a copy of this for the report. Whether yes, they have looked into, or my lord, they have only stated what they have stated in their opposition, that we have done, we have looked into.
Have you brought all the documents, FIR, that inquest report?
Inquest report, inquest report ache. Inquest report won't be supplied to us, my lord, because of we have the charge sheet, we have the copy of the FIR. FIR, the 161 statement by the, my lord, accused, where the accused themselves says Dharmesh Shah's personal phone was used. Dharmesha even in 164 says, yes, my personal phone was used. Police, CBI says, as you are the STD booth owner, so therefore that phone is of an STD booth owner.
Now, since Dharmesha allowed them to use their personal phone, Dharmesha is also
Milord,
part of the offense.
Milord, this
That
person,
cannot be ascertained.
this Vishwajit, Montu, Shubir, they are recorded criminals. They are not layman. Milord, suppose in a group of friends, one of the friends suddenly kills a friend, it's not that. They are recorded criminal record, holding with the criminal records of murder, n number of murders.
No.
Basically, I can in local language say supari killers. These people are supari killers of Barakpur, known to police from Halt.
However, you have submitted FIR, charge sheet submitted by the CBI.
CBI supplementary charge sheets filed by the CBI.
With the writ petition.
With the writ petition,
Now, after the investigation, the charge sheet,
nothing.
the supplementary charge sheet which they filed.
Yes, yes, that is also annexed.
Annexed.
Milord, I have also annexed the letter written by the CBI said that this investigation is not proper. CBI himself writes, after I make a complaint to the Union Minister, indicating the points. The Union Minister refers it to the CBI what is going on. They then cough up, say this investigation is not correct.
That letter is also
yes, part of record. Then I come with a writ petition with a prayer that removes CBI.
All these documents scattered.
Milord, I can make a compilation of everything. Milord, whatever I have collected from the.
Have you?
No, not done yet, but I can. Milord, give me a 2 days time, Milord, within this, because Thursday is the last day. Thereafter, it's a holiday. Yeah. All documents, Milord, within that period, I can make a compilation.
I am
and come back.
hesitating to say so.
No, I can make a compilation.
When you have already bought on record, I cannot make.
Yes, I make a compilation.
You give me compilation. Right. Allow me to read all this and their charge sheet, supplementary charge sheet, and the Tata's report.
The report they haven't supplied to me.
They are supplied to the court.
I cannot assist on that, what they have stated.
No, up to that part you just give. I don't want any opinion from your side. Either from the legal expert or from the litigant. Okay, I want to apply my mind. I want to read the FIR. Thereafter, the charge sheet, the supplementary charge sheet. Thereafter, the supplementary charge sheet filed by the CBI after holding reinvestigation. Everything. And their status report. Then only
very good.
I shall be able to make up my mind what is to be done. Okay. এইটা উনি দেবেন I am doing next week. Whether sufficient 3 days sufficient?
সব আছে তো available তো তোর কাছে এটা
Yes.
compile যা যা
Just next week. You tell
My lord, it can be fixed after 22nd, your lordship.
ওর সাথে বসে সিরিয়ালি কর হ্যাপাজার্ডলি হলে আবার কনফিউশন হবে ডেট ওয়াইজ সিরিয়ালি পর পর রেখে কর
Okay, so in that circumstance, 24.
I have no problem. It's up to them.
Come on, 24.
Much obliged.
But that with আবার ওইদিকে ছুটি তখন বলবে এই নেই ও নেই Okay, 24 there is no
problem.
Inconvenience. Okay, come on 24. আচ্ছা এই one thing that আমরা সেই বিয়েটা দেবে Trivedi will not be available.
My lord, Mr. Trivedi will not be available, my lord, on 22nd and before that, my lord. Any day before 22nd or after 22nd, my lord, would be convenient.
Actually, on that date, he just hand over the compilation of the document.
Yes.
Nothing, no hearing will
My lord,
be there.
whatever deems fit and proper, my lord. Whatever falls from you.
Yes, sufficient. On that date, no hearing, no decision shall be taken, just your handover.
Okay.
The compilation of the documents, related documents, okay?
Much.
So I'm making note this week.
Okay.
My lord, even my lord, without calling for my opinion, if I may beseech my lord to have a copy of that report. My lord, I will not form my opinion. I will wait till my lord looks into it and come
My
out.
lord, the report is a confidential document, my lord.
It cannot be because there is a
And it
charge
has
sheet now.
already been,
There is
my
a
lord,
charge
has
sheet now.
been
It cannot be a
inspected by our
confidential report.
officer, lordship.
কি অর্ডার আছে দেখুন তো রিপোর্টটা কি টেকেন অন রেকর্ড করা হয়েছিল?
My lord, under the law, my lord, I am entitled to copy of any report filed by the police.
হ্যাঁ?
The confidential about.
By the it is part of the record. It's public document.
No, even I can apply for a certificate.
Not given any seal.
The question to that.
হ্যাঁ
I can look into it. No, no, it's-
envelope or
No, no,
anything.
no.
Nothing like that.
It has been part of record now. Now he is entitled to get certified copy.
My lord, under that circumstance, I have to take instructions.
What
from
instruction? It's a
What instruction you have?
problem. হলো এই সবেতেই instruction.
Everyone after few days, after few years, everyone will come to your chamber to take instruction. Tell Nukil Babu what is to be done. Instruction. It has become part of record. Even he can get a certified copy. So what will be the problem if we allow him to have a look? It has been taken on record by the school. It is not like a CD.
Absolutely.
And the accused person will not be able to see. He shall have no access.
চার্জ শিট হয়ে গেছে।
It is not that. Ask your senior to come.
Much obliged.
He will be junior. Okay, you just.
But I can ensure what has fallen from my lord, I will not form an opinion until something comes from my lord. I will not even address what in the compilation as well. It's for my knowledge. Even if I find from the report everything is.
No, why I am scattered?
Yes.
Being added.
Yes, absolutely.
Current pleadings.
Yes, yes.
Application,
Yes.
everybody in opposition, everybody
Yes.
such and such. I am to find out. Hence, I am asking that you just.
Yes, compilation will give.
So that at
Yes.
one glance I can.
Yes.
Okay. Next.
36.
36.
I'm appearing on behalf of petitioners.
Yes. Please for your understanding.
Lordship, in this matter, I am led by Dr. Sutanu Kumar Patro. For the school service commission, in this matter, I am led by Dr. Sutanu Kumar Patro, Lordship. He is engaged in a revision bench, my lord. I am praying for fixing a date for hearing of this matter.
You have not been given authority to assist the court.
Yes, your lordship.
Oh. So what do you want? So what's filed? None has filed. You are filing.
I am filing opposition, my lord. Opposition is also ready, my lord.
Opposition filed on behalf of the
School
Service Commission and the affidavit in reply filed to that opposition on behalf of the petitioner are taken on record. PARTHA learned advocate appearing for the respective parties, list the matter for further consideration. When your senior will come?
24th,
24th.
24th.
Okay. On 24th.
Grateful, my lord.
Thirty-seven.
37, I put the respondent, my lord.
Disciplinary proceedings. Huh? Affidavit of opposition.
Duplicate copy, my lord, which has been lost of the opposition copy from the court record. So, my lord. Reply copy दिए थे? Copy दिए? हाँ, then copy नहीं है। ना ना।
Your good name, please, Mr. Vishwas.
Amal Kumar Dotto, my lord.
Doctor.
Yes, my lord.
Acha, Mr. Dotto submits that the affidavit in opposition used by the respondent had already been submitted in the court. But on close scrutiny of the record, it is not. But on close scrutiny, but the such opposition is not with the record. Stop. Hence, the copy of the affidavit in opposition along with all annexures thereto supplied by Mr. Dotto is taken on record, and that copy of affidavit in opposition shall be treated as the original affidavit in opposition used on behalf of the answering respondent.
Yes, my lord.
ঠিক আছে? আচ্ছা, and affidavit in reply filed by the petitioner to that affidavit in opposition. Reply.
My lord, reply copy not served me, my lord.
Petitioner to that affidavit in opposition and kept with the record. You have not served copy. So make a copy and give him. Has the learned advocate and at the further consideration. So when it would be fixed? Next Thursday. 18 many matter has been fixed. 19th, open it on that day.
Grateful.
Yes. Now.
Part header matter, I don't know, 38.
Is your other side?
Kindly remember this matter. This matter relates to the remuneration of the health instructor of the school. The Lordship will kindly remember after the matter. You will vary. Proposition filed by the school saying that we are not appointed you. We are not giving me an appointment to never work. But subsequently it was placed before your lordship document where the teachers council meeting was there and the teacher in charge of the particular school was present in the teachers council meeting and admitted that their teacher is working there and we will take steps for release of the salary. That is why a lawsuit directed the school to come with a proper instruction and they will something. Tell the people are.
Who is appearing for the school? Kopil Chandra Sahu appeared on behalf of the school on 16th February 2023. I got the occasion to hear 19th December on that day Tran appeared on behalf of the school authority.
Already appeared. You already appeared. If something is really hard, you know, something is really hard. Yes, that's why you hard thing to man hard the middle part. Middle hard part.
No. Hard Mr. Both and advocate appearing for the petitioner, school authority is unrepresented. It is clarified that if, although I stated, but this order I stated, if on the returnable date none appears to represent the school authority, writ petition and writ petition shall be taken up for hearing.
Next moment,
same school.
Kopil Chandra appeared in that. School was appeared.
School appeared on Solo.
No. Appeared.
So, Mr. Court, court is to ascertain what is the actual stand of the school. Whether question is whether you worked or not.
Now I work, admittedly I work.
It is your game.
No. School also admitted that I work. School also admitted I work.
By filing affidavit.
By filing affidavit. But school says, school says there is no appointment. But kindly, they are affidavit of.
So how you got the opportunity to work for the school?
That is they say what they are trying to say.
There is no appointment letter.
As per their version, there is no appointment. But admittedly I was engaged by the school as an invigilator to a different school. But the practical instance in that affidavit tried to substantiate that he took charge in 2000. He don't know about the earlier thing. But when he joined, I was working. He asked me to supply me my appointment letter. The earlier headmaster of the there is a term going on. Administrator was appointed. School Almara was under lock and many things were happening. So he could not able to find out my appointment letter. As such, he was of the impression that I have no appointment letter, but I have one. Admittedly, I have. But can you look into the paragraph of the independent opposition?
So, whether any selection process was initiated?
Yes. This is the contextual. This is a
How to engage you as a contractual teacher?
Professional teacher.
Yes. Not to appoint in a substantive post, but to engage you as a contractual teacher.
Yes.
Any selection process was taken?
That was taken in long back in 2009. I worked 9 to 12. 2009 to 2000. If you lost kindly task.
Now, whether any provision that such appointment shall be approved by the PI or
what happened?
So it is not possible of the state also to say whether this appointment was to the notice of the DI or not. It's college or school? School. That means DI.
In vocational courses, state used to pay a lump sum. From the state lump sum, the school used to pay the honorarium or the remuneration to the teacher. That was the rules and that was
from the state.
From the state. Nowadays, what happened? the state government directly paid in the account of the
respective teacher.
But at that point of time, lump sum is paid to the school. In favor of the school.
So bring Mr. Sahu.
That's your lordship. I shall serve your notice.
Not this week. I am making it not this week.
I shall serve your notice. But
Both the matter. 38 and 39.
But let it be on one thereafter, because if they accept them.
So 19.
Kindly direct people and all. Let's see this. I'll have another as well as
As having heard the learned advocate appearing for the petitioner and the state, and upon considering the facts and circumstances of this case, I am of the view that here presence of the representative of the school authority is much required for rendering complete and effective justice. Complete and effective justice. In view thereof, the petitioner is directed to serve a notice upon the learned advocate as well as the school authority, learned advocate who entered his appearance on behalf of the school authority on earlier occasion when the matter was taken up for hearing, and also upon the school authority giving intimation regarding the next date of hearing. Stop. List the matter. On 19th. On 19. And file affidavit of service on that day. File affidavit of service on the returnable date. 38, 39, same order.
Actually, what happened after the school appeared, your lordship has taken care of the school at that time. Your lordship has directed him unless you pay the money. You have to pay the money to the pocket of the teacher. That's why. That's why. That is the reason I gave you a service of school.
Okay.
40. I appear on the other.
On behalf of the respondent, Mr. Pranab Bandyopadhyay is appearing.
Perhaps it is not required. One of the previous two occasions,
that matter.
Yes. Only awarding of 6 marks. They were to get instructions. They on repeated occasions.
That is Mr. Bandyopadhyay.
Mr. Bandyopadhyay is on legs, my lord. His matter is going on at this moment.
So when it would be comfortable for him?
Tomorrow.
Okay, tomorrow.
You get some decisions in the list.
Place at such a place it will reach.
41.
41, I am for the state, my lord.
Not this week.
My lord, kindly, my lord, make adjourn for a fortnight, my lord. Because the last occasion, my lord directed us to serve a notice upon the University of Uttarakhand. So we served. It is the regarding the false certificate and mark sheet of a teacher, my lord. And we served later, and January 2nd on 2024, they replied that we have to deposit 1,000 for the report. And for that reason, it took some time, I hope, my lord.
Okay. 30th January.
The instruction.
30th January.
30.
আর কি করতে হবে